May we begin with this opening ceremony? All right, thank you. Good morning and welcome to National Mood Workshop 2021. Before we begin, allow me to introduce myself. My name is Pyeong-sin Yu from the Multimedia University, MMU, and I will be your MC for today. Beforehand, may I please request all the participants to turn on your camera? All right, thank you for your cooperation. Announcing the entrance of the honorable distinguished speakers, Mr. Surinder Singh, the Vice President of Malaysian Bar, and Associate Professor Dr. Salida Suhaida Nik Saleh, the Dean of Faculty Sharia and Law from USIM. A warm welcome to our honorable guests and to all of you. First of all, we would like to express our gratitude to everyone for allocating your time today to join us. To begin our workshop with a blessing, may I please invite Mr. Muhammad Haikal bin Che Hasim to lead the Doa recitation.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wassalatu wassalamu ala Sayyidina Muhammadin wa ala alihi wa ashabihi ajma'in. Ya Karim, Ya Wadud. Sesungguhnya kami berhimpun pada hari ini bagi menyatakan kesyukuran di atas kurniaan-Mu yang tidak ternilai. Jadikanlah kami hamba-hamba-Mu yang sentiasa bersyukur, sama ada nikmat yang sedikit, lebih-lebih lagi nikmat yang melimpah ruah kepada kami. Ya Allah, Ya Rahman, Ya Rahim. Engkau berkatilah dan rahmatilah perjalanan Majlis Nasional Workshop pada hari ini. Sesungguhnya Engkau Maha mengetahui bahawa kami di sini ingin menimba ilmu-Mu yang sangat luas bagi mengembangkan ilmu pengetahuan kami sebagai hamba-Mu yang Engkau redai. Justeru, berkati dan rahmatilah perhimpunan kami ini. Kurniakanlah kepada kami ilmu-Mu. Sinarilah hati-hati kami dengan cahaya dan hidayah-Mu. Semoga dengannya kami mudah menerima dan menghayati serta mengamalkannya. Ya Zal Jalali wal Ikram, kurniakanlah jua kepada kami kesihatan anggota, kecergasan minda, ketenangan jiwa, kekuatan semangat. Semoga dengannya kami mampu mendapati cabaran, berdaya saing dan mampu mengangkat martabat diri, keluarga, masyarakat dan negara. Rabbana atina fid dunya hasanah wa fil akhirati hasanatan wa qina adzaban nar. Wa sallallahu ala Muhammadin wa ala alihi wa sahbihi wasallam. Walhamdulillahi Rabbil Alamin. Amin.
All right, thank you, Mr. Muhammad Haikal, for the Doa recitation. May this workshop run smoothly. Now, it is our pleasure to invite Professor Dr. Nik Salida Suhaida to deliver the opening remarks. Please welcome.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning to everyone. Thank you, Ms. Pyeong-sin. Sorry me if I'm pronounced it wrongly. Thank you to each and every one of you for being here virtually with us today. And if it is not because of the outbreak of COVID-19, we will have been able to warmly welcome everyone to the Faculty of Sharia and Law, University of Science Islam Malaysia today. And before I begin my speech, allow me to express my sincere appreciation to Mr. Surinder Singh, S.O. Chain Singh, Vice President of the Malaysian Bar, for spending his valuable time with us today in this program. Thank you very much, Mr. Surinder. And as the Dean, for your information, today is my second day of my appointment anyway, and I'm very grateful to be here. And I warmly welcome everyone to the National Mood Workshop virtually today. And first of all, I also would like to congratulate USIM Mooting Club and its 6 other collaborators from University Kebangsaan Malaysia, University Utara Malaysia, University Teknologi Mara, Advanced Tertiary College, Multimedia University, and International Islamic University Malaysia for initiating and conducting this program today. The National Mood Workshop aims to expose law students, especially from these universities, to the basic idea of mooting. As such, there will be a number of prominent speakers from different backgrounds to share their experience and tips on mooting, such as sharing session with the former champions and former mooters who have participated in different moot competitions. Mr. Rafael Cook, the moot master from the University of Malaya. I hope Mr. Rafael Cook is now with us. And Associate Professor Dr. Juria, IIUM moot master. Mr. Joshua Teh Hong Wen, UUM moot master. And Mr. Albertus Aldio Primadi, Senior International Case Counsel from the Asian International Arbitration Center, AIAC. And this program also creates an understanding on the basic knowledge on different types of mooting, such as the simulated court and arbitration, as well as to encourage law students to get involved in mooting internally and externally. I strongly believe that by getting involved and participating in mooting, the students will be exposed and experience the closest environment to the real practice during their undergraduate studies. And not only that, the students will also explore and learn many new knowledge and areas of law which have not been taught in any classroom when they get involved in any mooting competitions. And this will be an added value for the students to succeed in today's competitive world. On top of that, getting to know each other peers from other institutions and the experience gained from participating in mooting will be valued the most and memorable indeed. As I do not intend to take too much of your time, as the Dean and on behalf of the Faculty of Sharia and Law, University of Science, Islam Malaysia, I once again would like to thank and congratulate to all the organizing committees for all your efforts and hard works for making all this program a reality. The same goes to all our guest speakers, of course, who will be sharing their valuable experience, tips and knowledge with us today. And I hope that all participants will gain as much as knowledge as possible from their respective sessions. And I also hope that this program will be continued in order to contribute and put the legal profession of the country to a greater height. With that, I thank you.
Thank you, Professor Dr. Nixelida Suhaida, for the wonderful remarks. Next, may we invite Mr. Surinder Singh for the opening remarks. Please welcome.
Yes, a very good morning to the honorable guests, lecturers from UCIM and all other universities present here today. I would like to say that I'm sorry for not being able to be with you today in this occasion. With COVID-19 still raging on, we have to adapt to the new normal of social and physical distancing. I would like to thank and express my gratitude to the UCIM Mooting Club for inviting me here today through this video link to speak to all of you. This demonstrates the power of technology in bringing people together despite being physically apart. Finding innovative ways to do things is the hallmark of development. When I see students mooting, I see the effort and patience that goes into these arguments. Into the argument is not merely a matter of standing up and speaking to a judge or to an opponent. Mooting is essentially a court-stimulated hearing whereby participants analyze an issue, prepare written submissions, and present oral arguments before a judge. Did you know that moots have been around since the 1700s? It was first developed more than 500 years ago in the Inns of Courts in England, where young lawyers training to become barristers were required to conduct oral exercises before more experienced lawyers. Clearly, this was a good habit and it survived the test of time. If I were to put it simply, mooting is the basic building blocks for lawyers and law students who are keen on pursuing a career in litigation upon the completion of their law degree. However, it would be simplistic to say that only students who are keen on litigation and advocacy will benefit from mooting. Arbitration is a similar to mooting as well, as it is a procedure in which a dispute is submitted by the agreements of the parties to an arbitrator to make a binding decision on the dispute. It is a form of alternate dispute resolution where parties do not go to court, but the procedure of both arbitration and mooting is similar to for a law students. You must engage in your legal advocacy skills to convince the judge or the arbitrator of the merits of your case. When mooting and arbitration, what mooting and arbitration will do is to help you hone your skills in persuasive advocacy. It will be a good analysis of the legal problems and to approach it from a strategic standpoint. It forms an important role in your legal education, and it has been part of the process for lawyers for centuries. Your way of thinking will change. You will be able to engage and think deeply about topical legal questions. You will learn how to enhance your advocacy and speak confidently in public. Your legal research and writing skills will also improve as you will need to prepare written submissions. You will also be able to learn from your peers and work closely with them and share important ideas. It allows students to promote a spirit of friendly rivalry as well as increase the camaraderie as well. All in all, I will say that your competence as a law student will be strengthened through your experiences in mooting and arbitration. Each mooting competition will focus on a specific area of legal argument, ranging from contract law, international law, to constitutional law, and so forth. You will be able to see the two sides of an argument, and in the process, you will learn and you will gain a better understanding of areas of law that you are not familiar to begin with. That I've talked extensively about the importance of legal research and writing, let's discuss how you should engage with a judge in your moot arbitration. Even if you do not intend on becoming a litigator in the future, you will need to be a convincing public speaker. As lawyers, you will need to speak to clients and with other parties, so mooting and arbitration can hone your skills by encouraging you to be alert and able to engage spontaneously with the judge. You cannot expect to succeed in a moot just by reading from a prepared script or memorizing it. Judges will ask you questions and you will be expected to answer them cogently. You will be able to master the art of persuasion, and this will build up your confidence. As a lawyer myself with years of practice, I want to tell you that process of mooting and advocacy is highly rewarding. You will cross paths with various opponents and you will be able to learn skills that you would not have if you did not participate in mooting and arbitration workshops and competition. You are young. Take this opportunity to immerse yourself in the new experiences such as mooting and gain better understanding of the ever-evolving legal landscape. On behalf of the Malaysian Bar, I would like to remind you that the future of the bar rests in your hands. If you have the right attitude and the right preparation, the world is your oyster. I would like to thank Yusim for giving me this opportunity to speak to all of you this morning. I hope that what I've said today will encourage you to pursue mooting and arbitration with deep interest. And perhaps one day you may venture into a career of litigation or arbitration. You'll be fighting for the rights of your clients and you will be able to deliver your submissions to the judge or the arbitrator with aplomb. You will understand that to be a good lawyer, you do not just need to have good advocacy skills. A lot of effort goes into good sets of submissions and I truly believe that mooting will help you get there one day. With that, I look forward to seeing you all at the bar one day. All the best to everyone. Take care and stay safe. Thank you.
Thank you, Mr. Surinda. We are enthralled by your speech. Without further ado, I would like to, because we are ending quite early and our first session start at 9:30, we will have a break for about 15 minutes. And at 9:30 a.m. sharp, we shall begin with our first session. On behalf of the National Mood Workshop Committee, we would like to extend our gratitude to Professor Dr. Nick Salida and Mr. Surinda for coming with us today for the opening ceremony. May you please open? Yes, we would like to have an photography session. May all the participants turn on your camera. All right, thank you. Okay, I shall begin. 1, 2, 3, smile. Again, 1, 2, 3, smile. All right, thank you everyone for your cooperation. And And once again, thank you, Mr. Surinda and Professor Dr. Nick Salida. I
Thank you
see
very
that we are,
much.
Thank you.
yes, thank you. Thank you. I see that it's only 9:19 and our speakers here are already here, if I'm not mistaken. Mr. Syed Mohammad Ashraf, can you open your camera? I see Mr. Sahain is here. Miss Ashwati. Miss Ashwati is here. How about Mr. Syed Mohammad Ashraf? Without further ado, I would like to pass the floor to Mr. Muhammad Fitri Shafiq to begin our first session.
Thank you, Ms. Yu. Beforehand, I would like to remind all the participants to keep turning on your camera. Thank you for your wonderful cooperation. Announcing the entrance of our distinguished panelists, Mr. Syed Muhammad Ashraf, Ms. Ashwati Ashley, and Mr. Sahin Nada. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all of you. Welcome to the first session of our National Mood Workshop. I would like to introduce myself. I am Fitri Shafiq from UIT and Faculty of Law, and on behalf of the organizing committee, will be your MC for our first session today. Honorable guests, ladies and gentlemen, now let's begin our event with the first session, which is Introduction to Mooting. Why should you join? This session will be a forum session. Will consist of 2 rounds, and for each round, I will ask one question to each panelist. Each panelist will be given 7 minutes to answer the question. First and foremost, I would like to ask all the distinguished panelists to briefly introduce yourself. Please welcome.
All right. Hello, everyone. Good morning. I'm Syed Ashraf. I'm a third-year law student from IIUM, and my mood, which was literally less than 2 months ago, in which my team won the championship. And currently, I'm in the IIUM's team for the William Seavis International Commercial Arbitration Moot, which will take place in March next year.
Okay, maybe I'll go next. Can I just confirm if everyone can hear me? Okay, thank you so much. Maybe before I begin, let me first thank the organizing committee of the National Moot Workshop for inviting me. Thank you so much, and for everyone for joining. I'm very privileged to be provided this platform and share my humble moot journey with you guys, and maybe some tips and tricks what I've learned over the years. So My name's Ashruti. You guys can call me Ash. I'm a third-year law student. I'm from UUM Kedah. And yeah, my mooting journey basically started when I was in year one in my internal UUM International Humanitarian Law Moots, where my team won the championship. And I've kind of remained my streak in the IHL Moots, where I joined joined the national level competition in when I was in year two, where my team also won the championship. And 2 weeks ago, we won again uh, as well. And currently, I'm prepping for the internationals, which will be in March this year. So yeah, that's basically my mood journey.
Okay, hi. My name is Sahin. Can everybody hear me? Okay, thank you. So my name is Sahin. I'm from UKM. I'm a fourth year student. I've been mooting since I was in my second year, and all the way up to now. I just finished the KL Bar E-Moot. So that was last month. So thank you very much. I think that's all about me briefly. Thank you.
Thank you to all our distinguished panelists for today's forum. After getting known with our distinguished panelists, now I will briefly share on some of the achievements of our panelists in mooting. Our first distinguished panelist today is Mr. Syed Muhammad Ashraf from IIUM. Talking about his achievement in mooting, Mr. Ashraf was a champion and been awarded as the best oralist for the Grand Final NAMCO 2020. Mr. Ashraf will be presenting IIUM and Malaysia at the 28th Annual Willem Davis International Commercial Arbitration Moot 2021. Our next distinguished panelist is Ms. Ashwati Ashley from UUM. Ms. Ashwati has a very vast experience in mooting, in which she has represented our country under the 18th Red Cross International Humanitarian Law Moot Competition 2020 in the Asia Pacific rounds. Her achievement began from both Dr. Hamza Hashim Moot Court Competition 2019 and the 17th National International Humanitarian Law Moot Court Competition 2019, where Ms. Ashley successfully advanced championship on both competitions. And recently, Ms. Ashley just won the 18th National International Humanitarian Law Moot Court Competition 2020. Lastly, we have Mr. Sahin Nada from UKM. Mr. Sahin's achievement in mooting is so outstanding. Second place in Tun Sofia National Constitutional Law Moot Court Competition 2018. He was also participated in Willem Davis International Commercial Arbitration Moot 2019, semi-finalist in Law Asia International Moot 2019, semi-finalist in Kuala Lumpur Bar E-Moot Competition 2020. Now, moving on to the first question of our first round. I would like to direct the question to Mr. Ashraf. Mr. Ashraf, based on your great experience in mooting, could you explain to us on what is actually mooting is all about, perhaps by giving a definition to it? Please, welcome.
All right, thank you so much, Fitri, for the nice introduction. So back to your question, what is mooting all about? Sounds like a simple question, but for those who are unfamiliar with mooting, or for those who have never tried it before, I think it's important to get a good understanding on what it actually is and what goes on throughout the process. So to put it simply, mooting is basically an activity which replicates a legal proceeding. And that can either be a court proceeding or an arbitration proceeding, depending on the competition that you join. And when I say proceeding, it doesn't just refer to the oral hearings. A lot of people, especially students, always have this misconception that mooting is merely presenting arguments in front of judges. Of course, that's true. The oral hearing is like the main highlight of it, but there's actually a lot that goes on before that. So in a normal competition, what usually happens is that students or participants would be given a moot problem on a certain case. And that also depends on the competition. It could be a commercial case before an arbitral tribunal. It could be an international law case for the ICJ, human rights case, cyber law case, the list goes on. And the moot problem would usually contain issues that are complex, that are quite difficult, but I would say evenly balanced so that each side has quite a fair chance to equally argue and demonstrate their skills. And this problem would usually be given a few months before the oral rounds, depending on the competition. So some competitions would release the problem like 3 months before the oral rounds, or some even earlier than that, depending on how big the competition is. And then there's also like bigger competitions like JESUP or VIS, which would release their problem, I think even up to 5 or 6 months before. So in that very long period in between, what happens is that you and your teammates would read the problem, of course, which sometimes can be very long. You would discuss the issues and of course conduct your legal research, which I think is the most important aspect in a competition.
May I please remind all the participants to mute your microphone if you're not speaking. Thank you.
All right, so coming back. So, and after that, you also are required to write your written submissions, which are basically your legal arguments, but in written form. And the only difference is that your written submission is usually more, I would say, detailed. It explains your arguments and authorities more thoroughly as compared to what you would submit orally later on. And you cannot take your written submission lightly because in certain moot competitions, your oral submissions may be bound by your written, meaning that you cannot like depart from it and make new arguments. You must use the same ones that you have put in your written. But then again, not all competitions are like this. Usually the big ones don't really practice that. That's one reason. And then there's also usually the best written submission category or award in every moot competition. So you might want to try and win that one too. So once that is complete, only then are you expected to do the oral submissions, or in other words, present your case or your legal arguments before a panel of judges or arbitrators. So usually there'll be like 2 counsels representing both sides. And just like normal hearings in real life, you are also expected to persuade these judges with your oral arguments with only one purpose, which is to make sure that they decide in favor of your client, that is the person, the company or the state that you are representing. And in the process of doing that comes, I think, the most daunting or most scary part of mooting, which is that the judges will start to ask you questions, be it on the facts of the case or the law itself. And this is actually to assist them in understanding your client's position. Well, most of the time to assist them, because sometimes there are judges who really just want to stump you. So by assisting them in answering their queries, this will actually help them to understand your case better and consequently help them to determine who will win the case. So that's why research that goes beforehand is very crucial so that you can actually get a very clear and full understanding of your case from all angles so that you can answer the questions easily. And I think it's also important to note that in mooting, each speaker has a very limited time to deliver their points. It could be 15 minutes, could be 14 minutes or even less. And the judges will interject and ask questions as much as they want. So you have to be very concise. And this is where flexibility would come in. So essentially, I think as law students, I think this is probably one of the best ways in getting a taste of real practice, because for now, this is the closest experience that you can get in appearing before a court or a tribunal. And this is also one of the reasons I think most law schools nowadays offer compulsory mooting subjects in their course. So yeah, that's basically a very brief illustration of the whole mooting process. Thank you. Back to Fitri.
All right. Thank you, Mr. Ashraf, for those insightful sharing with us. Next, I would like to ask Mish as a person who is very experienced in mooting competition and have a very inspiring background, what is your personal view on the expectation versus reality in mooting? Please welcome.
Thank you so much, Fitri. So, and also thanks to Mr. Sheikh Ashraf for the very well explained brief on what mooting is. I thought that was really a good introduction for especially those that have never mooted before. And coming back to the question that I was posed to by Fitri, expectations versus reality of mooting. I also believe that this is a very important question to address, especially for baby mooters and those deliberating on whether to pursue moots. And I'm sure everyone has their own expectation on what mooting is, but maybe let me share with you my expectations of what I felt in year one before I joined my first moot. And like I said earlier, the first moot I joined was the internal IHL at UUM. And at that time, I was a first year law student and I didn't really have any legal background prior to this because I was from the UUM Foundation where we didn't have law subjects. So my expectations of mooting was very vague, and the first and most jarring, I think, was the expectation that moot was a debate. And what I mean by this is that I thought that you could give your opinions regarding the case, and I think this is like very very wrong, and this is not the reality of moots at all. Mooting is basically about your capacity to argue persuasively and convince listeners to accept your particular stance. But the most important thing is that everything you say must have basis in law. So you cannot just express opinions or beliefs, but you need to submit in regards to the law and decided principles. And when answering judges during your moots, it's really important that you adhere to this and not merely just use facts to kind of support your case. So moot is definitely very different from debate in that regard. And secondly, is that people often go to moots thinking there's a very clear outline of what you should do. For example, like in our law exams where we answer problematic questions and the answers are pretty clear cut and it's kind of like a one answer fit all. But moots are very different where there can be a multitude of principles that can be submitted and all of them are acceptable. It just depends on how you submit them and how you support the facts and how you argue the case and how creatively you arrange your arguments to persuade the court, um, as long as those principles are founded in law. So mooting is definitely not rigid. It's you can be creative with your arguments and your submissions. Yeah, like I said, as long as they have some basis in law. And thirdly is that the expectation that people go into moots is that research is merely for researchers and mooters moot. They present oral submissions, but I think every single person in a moot team needs to be equally proficient in research. And research is definitely not one dimensional. Research needs to be very thorough and very extensive. And the reason that I say this is that if you don't research, it will really show in your oral submissions when you get pressured into questions or the judges ask for alternative submissions, and it will really be obvious if you yourself as a mooter have not done your research and you have merely relied on the researcher in your team. And I would definitely say, as someone who has been mooting for 2.5 years, research is the building block of success in a moot. If you don't do your research, you won't go far in moots. And when you do your research, it's really important to read the full facts of the case, the arguments of both parties, the judgments, the dissenting opinions as well. And when you research, then only you'll be really confident that you know the principles well. So yeah, research is super important and don't compromise on that. And moving on, another expectation that misconception that people have in regards to moods is the time involved. I think people underestimate the amount of time it takes to prepare for moods. So when it comes to national moods, usually the amount of time given is about 2 to 3 months to prepare. And believe me, those 2 to 3 months in itself is not sufficient to prepare for that 20-minute submission. Um, yeah, so definitely don't prepare for your moods last minute. And because once again, lack of research will show in your submission. And yeah, it takes weeks upon weeks to prepare for your moods. And even then, you'll be making amendments and doing research till the last minute. And even during competition rounds, you will be making amendments to your scripts and finding out additional information to add to your case for the next round. So don't underestimate the time. Um, Next is in regards to the misconception that people say that only those who are very outspoken and fluent in English can excel in moods. I thoroughly disagree with this because, okay, maybe to reflect on my personal experience when I joined mooting in year one, I never really thought that I would go far because I was under the impression that only people who had like a high proficiency and bombastic vocabulary in English could excel. But I have seen my teammates who don't speak English as a first language excel at mooting. So I will 100% tell you that this misconception is not true and you can be great mooter regardless. And the reason why I say this is that mooting is an acquired skill. It's not something that you're born with. It comes with a lot of practice and vocabulary, clarity, smoothness of submissions. It all can be acquired through practice. But I won't contest the fact that fluency is important. So definitely, if you are wanting to move into moods, please do like work on it. But don't think that you need to have like fancy, flowery language to do so. As long as you're familiar with the legal terminology needed, and this legal terminology, like database, is also acquired through research. So after preparing for 2 to 3 months, you're obviously going to be very familiar with the terminology of the particular mood, whether it's arbitration, whether it's mediation, whether it's IHL. So don't feel discouraged if you're not like Nate, you don't speak English as a first language. And maybe some suggestions I would give in regards to this, something that's helped me personally is watching videos online of mooters submitting at the international level. I would highly recommend you guys to like search up the JASUP internationals because the standards in those moods are like outstanding, and making those mooters as like examples of how you can emulate them and kind of find your style based on watching those mooters is something really helpful when it comes to breaking this expectation of only English speakers can moot. All right, and then people also have this misconception that mooting is not a full-time commitment, but I would say that if you intend to go far in mooting, it definitely requires a certain level of drive, passion, as well as commitment. And the reason being so is that it requires a lot of time. And when something requires a lot of time, in order for you not to get burnout or like feel demotivated, you need to want to achieve something in moot. So yeah, there's also this misconception that you cannot join anything else while you're mooting. And I know as law students, we have like academics, law society events to juggle, and maybe a role in clubs or two. And on top of that, we would want to add mooting to our list of accolades. So it can definitely be quite overwhelming. And I won't lie, at times, my team and I definitely do feel overwhelmed with the workload, especially now since everything is online. And I'm sure everyone is suffering with the vast amount of assignments that are going on. But be selective of what you join and kind of prioritize moods if you want to pursue them. And also don't spread yourself too thin. Like choose what you're passionate about and choose it and go for it. And another maybe advice I would give to break away from this expectation is that Don't join moods simultaneously, especially if you're a baby mooter. Choose one and focus on it and do your best in it. Yeah, and maybe before I pass the floor to my learned co-speaker, Mr. Sahin, I definitely like to share with you something that my mood coach, Mr. Joshua, who you'll see in session 3 later, told my team and I during tryouts for IHL Nationals when I was in my second year. And he said that when you join moods, in order to be committed, you should have the intention to win. And the reason why I say this is not because winning is everything, but when you have the intention to win, it makes you work that much harder. It makes you work 100 times harder. And at the end of the day, even if you don't win, you will feel like it's okay, I've tried my best. And that's all that counts, right? So yeah, have this intention. Don't go in with like, oh, I just want to try it out. Do your best in it, and I assure you that you'll have a lot of fun doing moods, and you'll definitely learn something in the process. And that's something that I really hold on to when it comes to moods, in order to break away from this expectation of like not wanting to commit so much of my time to moods. It definitely helps me be more driven and passionate. So yeah, passing the floor back to the MC. Tree.
Thank you, Miss Ashley, for the sharing of your opinion on expectation versus reality in meeting. Before we end our first round for this forum, Mr. Sahil, I would like to know on how do you apply meeting in your daily life. Please welcome.
Hello, can you guys hear me? Thank you, Ashraf and Ashruti. Very very nice answers by you guys. So thank you also, Fitri. So how do I apply meeting in my daily life? Well, honestly, in my normal daily life, I don't really apply mooting when I'm, doing normal things. As much as I like mooting, I don't like it that much. But I think there are a lot of practical aspects that I have gained from mooting that I think often overlooked, but they have helped me significantly. I think the most important one would be my experience in my university as a student. So I'll try to break it up into a few parts. So the first one is how it affects me as a student. I think that there are two main points that I can take away from here, that I think if any of you join your first mood or your subsequent moods, you can try and try and see if you can get this as well. So the most obvious one is you're going to get a lot of skills with regards to your research. And it's not, you don't have to think that you're going to get something huge or some kind of monumental change in your skill set. It may just be as simple as learning how to use LexisNexis well, learning how to use your CLJ search functions efficiently. These are all things that you may not use if you don't have to. So aside from that, you'll also learn, what is the best case? Do I need to take a recent case? Do I need to take an old, outdated case? How do I differentiate between a landmark case and a case that is just too old, that is just completely irrelevant? So these are also things that you learn and you need to look out for when you are doing your research as a mooter. And if you look out for these things, you will realize that it really applies way beyond moot. Probably moot is only the very short-term place where you're going to use these skills. You're going to use it much, much more later on when you start working or when you move into other things in life. As lawyers or as a law student. So I think that's the first one, your ability to research and identify just roughly how your legal arguments work. The next one is your oral skills and your advocacy. So this, I believe, in daily life, I think a good example would be like right now. I can talk to you guys. I'm not very, very nervous. I'm not shaking. I can do this. But many years ago, I would not have been able to do this. I would have been a very, very nervous person. I used to shake. My knees and my hands would shake if I would speak in public. So I'm not a public speaker. So that was something that I was very, very shy about that. But so mooting had allowed me to understand the skill of just talking to people. It doesn't matter the size of the crowd now. So this is, I think, a very, very important thing, because it's opened up the opportunity for me to speak publicly and really now to become very comfortable with public speaking. So this is always a very good thing, and a very practical thing that maybe you guys would be interested to learn is it has very, very significantly helped me in all my presentations in university, my tutorial classes. All of these are things that I think it's not huge, but it has helped. It has helped. So I do apply those skills when I'm mooting. I do apply those mooting skills here, and I'm also doing it right now. If you notice, like I said, I have two parts of this whatever thing, right? I think this is something that we learn. I learned from mooting. I have two parts to this answer. This is a very mooting style of answer. So this is the second way, how the advocacy it helps you in your normal day-to-day interactions. And I think when you take these two skills together, in your general life as a law student, you'll find that you do utilize both of these skills a lot in a lot of your presentations, all your pitching, all your assignments. You'll find that the skills that you've gotten from Moot are applicable in so many different aspects. Now, that's just the studies part, but there is the other part of mooting, which I think is very important, which is really the crux and the most important thing, I believe, which is the ability to explain something and to convince another person in a very, not a very formal way, not a very strict and rigid way, but in a way that the people will actually you're trying your best to make them understand what you're saying. I believe this is a very underrated skill and a very underrated point that I think lawyers and law students should have. So the ability to take a point, a complex point, or if you feel it is complicated, if you feel it is a difficult issue, to break that down, make it simple, identify what is right, what is wrong, and explain that to another person. And that is something that I use every day in my daily life. That is the one thing that I do use in my daily life. So I think that's it for me for this first question. So how do I apply Moot in my daily life? First, it affects, I use it in my studies quite a lot. Second one, I use it just to communicate. But most importantly, I don't really use it in everything about my daily life. And I hope you guys also are not like that. Thank you.
Thank you, Mr. Sahin, for such a fantastic sharing session with us. By that, we end our first round of this forum. Now, we move on to the second round of our forum today. I would like to start this round with Mr. Ashraf. Mr. Ashraf, how does mooting change your view on legal advocacy skill? Please, welcome.
All right, thanks Fitri and also Ashwati and Sain for that very insightful answers. So, before I joined mooting, I used to think that advocacy is more of a trait, or in other words, that it's like a characteristic, a natural ability that you either have it or you don't. And it's quite silly, come to think of it, but I know a lot of people who actually think that way. And of course, this is actually wrong. And as Ashwati mentioned, it is after all a skill, and just like any other skills, anyone can master it through learning and constant practice. I know a lot of people who avoid joining mooting because they aren't confident enough. They feel like they need to reach a certain level of oratory skill, oratory powers, and this is not true, because you have to start at some point in time. Because what matters is not where you are currently at in your development, but what matters is your learning process, your learning curve. So someone else can be better than you now, but with constant practice and training, you can still eventually be as good, if not better than that person. So the most important thing, I think, is consistency in improving. That's why your concern shouldn't really be on how much you currently know or how much you are able to do, but instead how fast you can learn. So first, that's what joining mooting had changed my view on advocacy skill. But actually, it's not just on advocacy skill. I think it applies to any other skill in life. So that's the first one. And secondly, as law students, I think we tend to always focus more on the law, on the cases, the statutes, the provisions, which makes sense because that's the first thing that we learn in class. That's what we listen all day during lectures throughout the week. But I think in legal advocacy, when you actually have a case in front of you, what's more important is the facts of the case itself. That's what the judges or the arbitrators are really interested in. I'm not saying that the law is not important. It's still very much crucial as the facts. But one thing that I learned is to always emphasize more on the facts. Especially in a mooting competition where you only have 14 minutes, 15 minutes each to speak. So you don't want to waste your time explaining something which the judges probably already know. During one of my rounds in NAMCO recently, during the feedback at the end of the round, one of the arbitrators, who is a practicing litigator, said that when he goes to court, he doesn't really mention much about the law because it's all already in the bundle. What he does is just explain the facts to the judge and why the court should decide in favor of his client. So that's, I think, another thing that actually changed my perspective and also how I approach advocacy. And another thing, I think ultimately the most crucial thing that I learned, which is vital in advocacy, which my coach, Izan Fahan, always reminds me, is clarity. When I first started out with mooting, I think this was something I myself tend to always disregard. We really need to make sure that the judges understand you and that your points are clearly conveyed, just like Sahin mentioned just now. You cannot speak too fast. You must make sure that the judges are with you. And after all, it's not just a mere presentation. You have to see it as a conversation. And when you converse with someone, you don't really speak like a rap god, right? The same goes when you're mooting. You cannot be too fast and you cannot be too slow. And on that note, I learned that it's always best to use simple and succinct sentences because not everyone is able to catch up with long, complicated ones. And you must always have a good structure so that the arguments would flow smoothly and make sense. Because you don't want to be all over the place. You want the judges to follow you steadily throughout your whole submission. And one last thing, which I think is very important, is of course preparation. Another thing that I learned is that in legal advocacy, it doesn't matter how good of a public speaker you are or how high your language proficiency is. If you don't prepare well, then you're still going to be in big trouble. Because even experienced lawyers themselves who have been going to court for decades need to prepare for their case. So what more us who are still very new to this thing? So preparation here, I think, includes two important aspects which you need to master. First is substance, and second is style. In terms of substance, you really need to understand your case. Make sure that you know both the facts and also the law well, so that you'll be able to help the judge whenever they ask you questions. And in terms of style, you really need to put in the hours. You need to practice a lot so that you can actually familiarize yourself in submitting that particular case. Because at the end of the day, these oral presentation skills are definitely the ones that are going to increase your chances of winning. Because to be frank, when speaking up about mooting, we cannot ignore the fact that it is, after all, a competition. And just like any other competition, there is going to be some sort of scoring rubric. It depends on the competition, really. Like the one that I joined recently, they didn't really have like a proper scoring rubric. The judges can just like generally choose which team was better. But most other competitions have like a proper scoring rubric. And if you look at the rubric, there is usually going to be like certain marks allocated for things like demeanor, eye contact, body language, voice projection. So these small petty things are the ones that are going to actually distinguish you from other teams. So you cannot ignore style and just focus on substance. But of course, substance is the one that carries more weightage, but you have to master both in order to be above everyone else. So yeah, after joining Muting, these are some of the things that actually changed my view on legal advocacy skills. Thank you, Fitri.
Thank you, Mr. Ashraf, for a very inclusive sharing with us. Next, Ms. Ashley, I am wonder that between be the appellant or the plaintiff and be the respondent or the defendant, which one would you choose and why? Please welcome.
Thank you so much, Fitri. Maybe before I begin, I'd like to address something that Mr. Sahin said that mooting, he applies mooting and it makes him not nervous. I 100% am definitely nervous every time I public speak. Even though I speak in public, no matter how many times I moot. So that's definitely something I would love to learn from Mr. Sahin. Yeah, just wanted to address that. Anyways, yeah, back to the question of like between the appellant and respondent, which would I choose and why? Definitely, I'd like to begin with the fact that I'm not really familiar with moods with appellant and respondent because in the IHL moods they go with prosecution and defense. So maybe I will reply in this regard. And between the two, I would say that both have their benefits and challenges. So it's not like a one sided thing where prosecution is easier than defense. Both have their own pros and cons. And I'll start with prosecution. So the challenge with the prosecution is that the burden is heavier. You have to establish every single element. And the difficulty that it poses is in regards to time management. So because you're prosecution and you have to hit every single element, sometimes when the judges bombard you with questions or they interrupt you, it can affect your flow, and also it will prevent you from submitting on all your elements. So time management when your prosecution is definitely of the essence. And yeah, this is one of the challenges when it comes to prosecution. But the benefits of submitting as the prosecution is that obviously you initiate the submission, so you have the higher ground in terms of setting the tone for the proceedings. And secondly, you also don't have to directly respond to the defense's oral submissions. So you only need to rebut probably the principles that they lay down in their written submissions, or you submit in advance in regards to what you think they will submit, to kind of move the court towards your side of your stance as prosecution. So definitely the challenge of thinking on the spot is less. You'll be less pressured to think on your feet. And also the most obvious benefit and kind of advantage that the prosecution has is that you have ample time to prepare your rebuttals. So in IHL moods, each speaker speaks for about 20 minutes. So once prosecution is done, you have 40 minutes to listen to the defense's case then and then present your rebuttal. So you won't feel that nervous in comparison to the defense, which has to come up like seconds after the prosecution presents their rebuttals and straight away just address whatever they said. So on the other hand, the challenges that the defense has is that it is always highly recommended for the defense or the respondent to address points raised by the opposing team directly in their oral submissions, because it shows conviction, it shows poise, and it shows that you have a firm grasp of the law and you can think on your feet and you can submit in that regard. And if you fail to do this, 100% the judges will address the prosecution submission while you are submitting. For instance, like the judge will say, okay, so the prosecution addressed this point. What is the defense's stance on this? So you definitely need to be prepared for those kind of questions as defense. And as I mentioned earlier, you will have no time for rebuttal. So you have to be really quick on your quick on your feet and immediately address the prosecution's points in rebuttal. So just for your information, how rebuttals and surrebuttals works is that the prosecution should come up and try to dismantle the defense's case in their rebuttals, and the defense has to only address what the prosecution raised in their rebuttals. So it's quite a high standard to meet, where you just have 5 minutes to listen to whatever they say and then straight away come up and rebut them. So this is like one of the challenges that being the defense side work poses. But the benefit of the defense submission is that you don't need to establish all elements. So you can pick a few strong points and group them together for a very creatively styled argument. And sometimes this creativity can give you points in regards to style, and also creativity and conviction, which will definitely help you establish a certain rapport with the bench. Usually, what I do is I group the physical elements together or group the mental elements together. So these are like some points that you can take for submitting as the defense and making your submissions more interesting to listen to in comparison to the prosecution, which has to hit on element one, element two, which can sometimes be quite dry if not presented properly. So all in all, they both have their challenges. Personally, like the question that Fitri asked, I really enjoy being the defense because it gives you more room to be creative and assertive with the submissions. And if you do your sir rebuttals properly, judges really appreciate it and they do give extra marks for that. And but I will definitely recommend for you not to have favorites because you will definitely have to submit on both sides. However, in the IHL advanced rounds, after you get through prelims, if you get the highest score, you can choose what you proceed into the advanced rounds to. So in that regard, maybe you can choose which side you want to be, but please prepare for both. Never be one-sided in your submissions. Yeah. Passing the floor back to Fitri.
Thank you, Ms. Ashley, for such a wonderful input you share with us. Lastly, for the final question of our forum today, Mr. Sahil, maybe you could share with us on your tip when submitting before the judge. Thank you. Ms. Pradhan,
Thank you.
please, welcome.
Sorry, Fitri, I couldn't hear the question. Could you please repeat?
Right. For the final question of our forum today, Mr. Sahil, could you share with us on your tip when submitting before the judge? Please, welcome.
Okay, sure. Thank you very much. My tips.
All right.
My tips for submitting before a judge. That's a very difficult question. What are my tips? I guess let me try. I'll try and break it up into a few parts. So, I think the most important thing to know, I think Ashraf has mentioned this, is most competitions will have a rubric. So they will tell you what is the division of marks for, let's say, you can split it into a few things. There'll probably be one for English, how good is your grammar, how good is your language. There'll probably be another one in whatever manner it will be for your style, your body language, your eye contact, all this will be probably something else. Another one will probably be answering questions, and maybe another one will be your clarity and your general advocacy skills. So there are about four main aspects that you need to look at. So if you're just looking at purely at oral rounds, so I think I will try and answer this question in a few parts. The first one, I'll try to talk about the nervousness. How do you cope with that? Second one is how do you just the general language, and the third one is about knowing your judges. So the first one about nervousness. I think this is probably a very, very big issue for a lot of people who are trying to get into mood. Feel that I don't, maybe you might feel that you don't have the experience, or you don't have the ability to speak in front of people who you may feel is daunting. this is my opinion, because whenever I train young mutters, I mean first-time mutters, this is the common complaint they say. I'm very scared of the judge. What if the judge asks me a lot of questions that I don't know how to answer? What if the judge is an actual judge from High Court or Court of Appeal? They get very scared about that. So this, when you get very nervous and all, then you tend to shut down and you talk very, very slowly, or some people talk very, very fast. So my best way to cope with the nervousness, I learned this when I was doing my first moot. I was like everybody, very nervous, very scared to talk, very shy. But I realized something, and this is still the mindset that I have now whenever I go into a mood. I really try to believe what I'm trying to say. I really try to embrace that ideology that I'm trying to bring in that court, as if I really believe that contract was not breached. Before the mood, I really try to take that in. I really try to put that in my brain, that I really believe this. And I also try to remind myself that I'm the one who has done the research for all of these months, 2-3 months. I've done it. But I know what I'm trying to say. I understand what I'm trying to say. So this comes from preparation. When you really know what you're going to say, you understand it well, and you believe it, that really helps with the nervousness. For me personally, that is the biggest thing that has helped me. So this is the main tip, but that must come with preparation. It's not something that you just wake up one day and you're no longer going to be nervous to submit. It doesn't work that way. It must come with preparation. You must put in a lot of effort. You must really know every aspect of what you're trying to say. Be prepared for all the questions. Have it all in your head. And then this is how this is my biggest tip, because I feel a lot of people expect your nervousness. This is particularly from a lot of first-time meeters. They expect that as they get closer to the date, somehow they will become less nervous. That just doesn't happen. The nervousness is something that you control by your preparation. Not to say that if you're nervous, it means you're unprepared, but nervousness is not just going to disappear without anything on your part. So that's one nervousness. The second one I want to talk about is what is it? It was knowing your judges. So knowing your judges is something that is very important when you are submitting, because let's take the example of a national moot in Malaysia. Your judges will have a range of people. You have a lot of young lawyers who are probably ex-mooters. You have this group of people who will be one group of judges. You have the other group of judges who are maybe young lawyers as well, but are not mooters. So this is a very different set of people that you're dealing with. You will also have a lot of maybe more experienced, maybe more elderly lawyers who have their own very distinct style, the old-fashioned style. They want it like that. So, a criminal lawyer who has been practicing for 40 years, he's not going to change his views for you. He is set in his ways. And the same will apply when your judge is an actual judge who has to deal with people, talking to them and submitting before them every single day. So they already know what they like. They have a clear idea. So you have got, I would say this generally 4 different groups of people who are the different types of judges, and you need to know what they like. Because this is very important, because judges and older practitioners have a very distinct style which they like. I personally believe that a lot of judges, they will not like it if you do not submit enough on the law. I've noticed this pattern that, when I say judges, I mean actual like young arif, but I mean people who work as judges professionally, not your moot judge, an actual judge. They do have their certain preferences. They'll be very particular. Is this case the most recent case? Is it outdated? Has it been overruled in any or denounced in any court? They're very particular about these kinds of things. So you need to know your judge, and you need to be able to change your submission according to what your judge is like. And you need to be aware of that. So sorry if I'm taking a bit too much time, but you need to be aware of how is your judge reacting, how your judge is reacting to what you're saying. So this also comes into how do you know your judges. You may notice that some judges will get very, very bored and they'll be just staring up or something while you're talking facts. Some judges just don't like it. And I think this is something that you can't fight it, because there's no way to fight it. You just have to change the style of your presentation to suit the person who is listening to you. And I think that is a very hard thing to do, to be able to modify your speech while you're in the middle of giving that speech. But that is a very, very important skill. Some judges really just want to listen to law only. Some people just want to listen to your arguments only. So you need to be able to look at their face and try and understand what they're thinking. The next one is on your general speaking skills. I think the biggest thing that I think is very simple and it's not very difficult to do, but it will help a lot. But I notice a lot of people do not always do this. For me, I have a very clear structure. I think all three of us have spoken about structure and why it's important. So the reason why I believe it is important is because when you have a clear structure, and by clear, when I say clear structure, what I mean is a structure that can be understood by you and can also be understood by another person. This is very important. This is important to make sure that you don't lose the person halfway through your speech. You can have 15 points that are not organized, that are completely disorganized, and you're going to lose people very, very quickly. But if you have a clear structure, and you follow that structure, people will be able to follow you. They'll be able to know, okay, this person, Sahin, is at the first stage of the first argument, something like that. So if I may just briefly explain how my structure works, I'm not sure if this would be helpful to you or not, but I always use this one structure, and I've taught it to all my mutus who have trained with me. 4 issues, let's say you have 4 issues, meaning you have 4 submissions. I always use these phrases. So 4 issues means 4 submissions. I will be making 4 submissions today. For my first 2 submissions, this is how I will speak. But for my first 2 submissions, I have 2 grounds. So that means I have my submission as the first level, I have my grounds as my second level, and below that I will have my reasoning if I have any. So everything follows this very clear and very rigid structure. It starts with my submission. When I'm in my submission, I will explain my grounds. When I'm in my grounds, I will explain my reasoning. And I do not do anything deeper than that or anything more surface than that. So I think this is generally my tips for all the submissions. Thank you.
Wow, what a great closure from Mr. Sahin. I believe that those tips will be very useful for us in preparing ourselves for meeting. Ladies and gentlemen, as all of you might have been waiting for, now we proceed to the Q&A session. Any audience may start asking our distinguished panelists now. For those who want to ask, please turn on your mic. If there is anyone who has a problem with the mic, you may just put your question in the chat box. Please, welcome. Anyone to ask a question, please?
Hi, hello. I have a question.
Please proceed.
Hello, can you hear me?
Yes, very loud.
Okay. I have a question to panelist Said Ashraf or to any other panelist. For a baby mooter, as in a starter in the mooting world, I would like to ask, how do you cope with the time management with the studies and in like researching and preparing? Because like for starters, I view the muting community as very, I thought that it's a hassle because there's so much work to do, but yet at the same time, they also excel in their studies. So I'm so curious on how they can cope with so many aspects of life, but yet they don't flunk in their studies, but yet excel in mooting at the same time. So that's my question. Thank you.
Thank you. So, any panelists answer the question?
All right. This is what I did personally. I think most law schools give their students at least like some control over which classes they take and when. So my So my tip would be to take advantage of that scheduling freedom by registering your courses that will actually give you a very balanced schedule. You know, it can also be, I think it can be beneficial if you try to group your classes or courses together. Like this is what I did, either all in the morning or all in the afternoon, so that you have a few like large blocks of open time throughout the week. So these blocks will actually give you the opportunity to be more focused on your mooting stuff for a sufficient time of hours on a daily basis, rather than just doing it in between classes. So that's what I did personally. Thank you.
So we move on to, we have two questions here in the chat box. Firstly, the question is, what is the biggest crisis that any of the mooters ever face, and how do you handle it? So any of the panelists may answer it. Perhaps Mr. Sahin, all right.
I've not really had much of a crisis experience. So maybe Ashwati, would you like to, if you have had crisis?
Okay, sure. I think crisis is kind of a overstatement, but there was this time in my first IHL nationals where what happened was I went through the prelim rounds and realized the case that I was citing had actually been, the principle extracted from the case had been overturned. And even though in IHL cases are merely persuasive, it was kind of detrimental to our case when the judge asked, like, okay, so what happened at the end of this case? And how do you draw this parallel to the case at hand? So that was really my first instance of realizing, okay, you really need to read the case and you really need to know the case from start to end. You cannot merely just cite one paragraph from the case and think that it's sufficient. And I think that ties back a lot to what I said earlier in regards to research. When you research, it's not merely one dimensional. You need to make sure that your research is thorough and extensive. So the crisis was that we had to find a new case and we had like 15 minutes to the next submission. So thank God we had a really good researcher to help us and we managed to pull through. But yeah, it really ties back to, if there's anything that you guys take away from me today, is that research is so important. It's as important as anything like style and advocacy. So please do your research and don't end up in such situations like I did in my IHL nationals. Yeah, passing the floor back to you, Fitri.
All right, thank you, Miss Ashley, for answering the question. So for the next question is that, dear speakers, may I ask, usually how many law should we include in the submission? Is it as much as we can will be an added advantage? So perhaps Mr. Sahin, give your response to this question.
Okay. So I think if either Ashraf or Ashwati want to add on, yeah, then I'm sure you can add on as well. For this question, how many law? Let's, I think my short answer is as much as is relevant. It's not as much as is possible. It's not as much as, you don't have to put every single, back to our pre-Merdeka ordinances, all you don't need lah. But you just have to put as much as is relevant. So you need to be able to identify what is relevant to this area of law, what is not relevant, what is just too far away, what is something that is very, very close. So you will need to be able to, first, when you get your issue, you need to identify what area of law is this, because you have an advantage in moots. Moots are almost always going to have their question related to a specific area of law. You just need to figure out what that is. And I mean, in this, like for example, a constitutional law moot will probably have constitutional law issues and statutory interpretation issues. An arbitration moot will probably have an international trade law issue and arbitration law, as in a procedural arbitration law issue. So when you figure out what is the area of law, then you go in and you'll be able to understand how many, I'm guessing what you mean is how many statutes or how many cases. I believe that is what the question is like. So how many statutes and how many cases depends on how much is relevant. You don't need to be putting in every single the statutes. If it is an issue that has a statute to it, then you probably have to address those statutes to the extent that they are relevant. But when it comes to cases, you don't have to be putting down every single case that relies or relates to this issue. You just need to put the ones that are the most relevant, the ones that are perhaps the most recent, ones that are the highest court, your normal stare decisis principles, the ones that are in favor for you, not ignoring the ones that are completely against you. You just need to be able to put enough that you're going to give a clear picture. Now, this is the second part of the question. Is it as much as we can be will be an added advantage? I believe what you're asking is, if you put everything, is it good? That is not good. Because you're going to put too many things, you're not going to be able to explain it, you're going to be able to put it very briefly, and this is not going to be of any real assistance to you. You need to put what is relevant, the things that you can understand, the things that you want to explain. The things that you are not really going to be able to use, the things that you don't really appreciate, don't put it. It's going to be wasting words and wasting your time. Thank you.
Thank you, Mr. Sahin. So moving on to the next question. To all the panelists, how do you manage to stay calm and collected in front of the judges when they interject with really challenging questions? Correct.
Maybe I'll take this if it's okay with Mr. Sahin and Mr. Ashraf. Okay. So I think this is one of the most fundamental questions when it comes to people wanting to join moods. How do you manage your nerves? And I'll be honest with you, contrary to what Mr. Sahin, says that he's very confident in his submissions, I still suffer with stage fright when I present my moods till this day. Even if it's virtual. And I think something that has really, really helped, I agree with what he says, preparation is key. And when you go into your moods, just remember that you have spent so much time and so much effort to prepare yourself for this specific number of minutes, and do not let yourself be your downfall. Go in there, be confident. A philosophy that I have is fake it till you make it. Be confident, always believe in what you say. It's okay to be a little overconfident in moods as long as you're not disrespectful to the opposing team and, of course, to the bench. But always believe in what you're saying. And whenever you feel like you're kind of deviating or derailing and you feel like you're getting very anxious, take a step back, take a deep breath, and continue your submissions. But in regards to people who have like stage fright and anxiety before going into the moods, trust me, it is normal. My mood partner, before this, when we were submitting in physical competitions, his hands used to shake so badly. So a tactic that he had was to hold the podium. So when he held the podium is so heavy, right? So the judges cannot notice that he's shaking, and you can submit normally and submit confidently. Another way of maybe combating anxiety during submissions is to slightly slow down your pace, because when you get anxious, you naturally speak very fast. And this is something that my mood coach constantly tells me, is that when I get very nervous, I speak very fast. So I constantly tell myself, okay, when I feel like I'm getting nervous, I need to slow down. I need to look at the judges and make sure that they understand what I say, and whether like the pacing and everything is okay. So in regards to the second part of your question is when judges interject with really challenging questions. So you can ask any mooter. This is probably the hardest part of moods. How to manage when a judge is asking you really challenging questions and interrupting in the flow of your submissions, and sometimes you may not have the answer. And in this regard, I 100% would implore for everybody to know the facts of your case. you need to know the facts of the mood problem so well that in the event that you do not have a law to substantiate your answer, bring the court back to the facts of the case and submit from the facts of the case. This is like a final resort, but I would definitely say that you need to do your research so well that this does not happen. Always bring the court back to the law and then substantiate with the facts. But in a worst case scenario that the question is so challenging, bring them back to your main point, take them back to the facts of the case and assert that this is your stance. And sometimes the conviction and confidence that you exude will convince the bench that it's persuasive, because mood in itself is a persuasive submission, you know. But yes, of course, like what Mr. Ashraf said earlier, it depends on and Mrs. Sahin said earlier, it depends on the type of judge that you face, whether they accept these kind of things or not. So read the room and just maintain clarity, maintain your conviction, and do what you think is best based on the research that you have done. I think that's really important to have some confidence in yourself. Yeah, passing the floor back to you, Fitri.
All right, thank you, Mrs. Sri. The next question is, what are your tips on getting back to the flow of your argument after judges interrupt your submission? Perhaps Mr. Ashraf could give your response to this question.
Sorry, what was the question again?
What are your tips on getting back to the flow of your argument after judges interrupt your submission?
Oh, okay. I think this is all, you really have to practice this, because most people usually when they start training, they would follow their script. They would have a script. So my advice is that once you get closer to the competition, try departing from that script so that you can get more flexible with your case. So that whenever a judge like asks questions or like brings you to a different structure to your whole arguments, you will be ready to somehow argue in that kind of structure. So yeah, it's all practice, I think, because I approach mooting like like a sport, and in any sport you have to put in the hours. So this is to make sure that you are accustomed to submitting your case. So you have to practice so that you will be more flexible with your case during the competition. Yeah, that's my tip.
Thank you, Mr. Ashraf. So maybe two more questions. Okay, the next question is, as mooter, is there any other ways to improve ourselves in mood other than joining moods and watching mood videos? Please, any panelists?
I don't mind answering, or Ashwati and Ashraf.
Feel free to answer it.
Okay, all right. I would say no. I'm sorry, but I don't believe that there's any real way for you to train to be to train mood other than doing mood. I think you just have to join. Maybe you don't have to join a competition, but you have to join some kind of training. You have to put it simply, if you want to learn how to improve your mood, you just have to do it. You have to submit. You have to, if you want to improve your memorial writing skills, you have to write a memorial. You have to practice writing it. You want to improve your answering question answer skills, you have to practice that. Being in a setting where somebody's going to ask you questions, you're going to give them the answers. You have to practice it. If you want to practice or improve the way you deliver your points, you just need to do it. There is no watching videos is effective only for you to understand the flow or see how somebody else does it. The most important way for you to do it is for you to do it yourself. So I would say that the best way you're going to see that you're improving as a mooter is when you join moods. Because if you don't join moods, you're just practicing on your own or doing it internally with your mood club alone, you're not going to feel that you're not going to feel the pressure of being in a competition. You're not going to grow that much. So I believe that the best way is to join moods. That's for me.
All right. Thank you, Mr. Sahin. Now we move on to the next question, specifically for Ms. Ashwati Ashley. I would like the question is, I would like to address this question specifically to Mr. Ashley. How do you manage to learn the basics of IHL just for the sake of voting during your first year? As I believe many people face the difficulties in, even when we take it as our course. To rephrase my question, how to understand the area of law that we are not familiar with within the short period of time for the sake of voting.
Thank you so much, Fitri, and thank you for the question directed at me. I think this is a very relevant question when it comes to different types of moods, when especially when the law is not something that we are familiar with. Of course, it's slightly more challenging. And to directly answer the short period of time question, of course, if we have a long time, we can all be masters of IHL. But in a short period of time, you definitely need to go back to the basics and look at authorities. Where does the basis of IHL comes from? And in that regard, it's definitely the Rome Statute. So you start from the legislation that it's from, the commentaries of the legislation, other sources of international law, and then you go to like databases, which provides you cases for that particular law. So for Malaysian law, our database would be LexisNexis, but for IHL, it is case metrics. So you just have to type in IHL case metrics and you can find all the cases there. So I really implore you guys, if there's a specific area of law that you're not familiar with, always break it down into where does that law come from, what is the source of that law, and understand what the law is before going into what are the principles propounded by that law. And yeah, I hope that answers your question. IHL is a very difficult area of law, and to be honest, it's so vast that I too still am learning it after 2.5 years. But it's very interesting, and I would highly recommend you guys to join IHL Moots, because out of all the mooting competitions that I've personally seen, it's very fun because of the fact that the moot problems are fictional and they're very dramatic war crimes and crimes against humanity. So it's a very fun area of law to go into, and there's a lot of things that you can learn, and it's not impossible to do it in a short period of time, definitely. So yeah, passing the floor back to you, Fitri.
All right, thank you, Ms. Ashley. Due to time constraint, we would discussing on one more question. So for those who ask and your question is not being addressed, I'm so sorry for that. So the last question is, to all the panelists, how do we present the argument to the judge? Is there any procedural method to be followed? For example, how do we address the judge during submitting the fact and the argument? Right. Any panelists, please?
Shall we take turns answering this? Is that okay, Fitri? Just very,
Yes.
very briefly, and we summarize. Maybe.
Question
Since we are
is.
short of time. No, I understood the question. Sorry.
All right. Okay.
Okay, so we just
Sorry.
start off with how do we present to the judges? Is there any procedural method? Yes, there are procedural methods for every moot competition that you join, and it's very important for you to be aware of those differences. I'll give you an example. If you are in an arbitration setting, you will be referring to your judges as Mr. or Madam Arbitrator. If it is a tribunal, it may be Your Excellencies. If it is a court in Malaysia, it may be Yang Arif or My Lord, depending on what you choose. So the procedural way of addressing your judge is very important. That will also affect the way in which the flow of the arguments also vary for each competition. So you need to be aware of that. Is there any procedural method for you to address the facts and the arguments? I think this is not really a procedural thing, but it's a style thing. How do you want to do it? So for me personally, I very rarely will mention a lot about the facts of a case, as in the cases that I'm referring to. I will just state the principle of law that I'm using. I'll state the facts that I'm referring to, and I will make that into conclude all of that into an argument. So I do not put it separately. I do it try to do it all at once so that the person listening just doesn't have to think about too many things. This is how I do it. And if I may just answer very quickly the second question, do you prepare a script and then practice until you do not need it? For me personally, I do not start with a script. I start with an outline. And I do not end up with a script. I only stick with an outline. So I practice with my outline only. Okay. Thank you.
All right, thank you, Mr. Sahin. I would like to thank all the panelists today for a great talk and a great sharing session with us. Now let us have a virtual photo session together. I would like to invite all the participants to turn on your camera. Please, all the participants to turn on your camera. Don't be shy. All right. All right. Are you ready, guys? In 3, 2, 1, smile. All right. Thank you for joining us, especially to all the panelists, Mr. Syed Ashraf, Ms. Ashwati Ashley, and lastly, Mr. Sahin Nada. Next, we will be having our second session for the National Workshop. So I shall pass the floor to Ms. Abigail Sarah. By that, thank you. Assalamualaikum.
Ladies and gentlemen, I would like to remind everyone to please turn on your camera for this session. Announcing the entrance of the Honorable Speaker, Mr. Raphael Koch. A very good morning to the distinguished speaker, ladies and gentlemen. Welcome to the second session of the National Mood Workshop. Before we proceed, allow me to introduce myself. I am Abigail Sarah Kumar from University Utara Malaysia School of Law, and on behalf of the organizing committee, USIM Mooting Club will be your MC for session 2 today. Honorable guests, ladies and gentlemen, now let's begin the second session, which is the Memorial Surgery Research. Let's begin our session with introducing briefly the background of our honorable speaker. Our distinguished speaker from this session is Mr. Raphael Koch, Mood Master of University Malaya. Raphael Koch, known to many as Raphael, is an alumnus of the Faculty of Law, University of Malaya. As a mooting coach, Mr. Raphael is commonly associated with his massive contribution in successfully guiding countless of mooting teams to multiple victories nationally and internationally. Constantly raising the bar after each win, he is one of the driving factors to the mushrooming member of world-class mooters from the Law faculty. Mr. Raphael was actively involved in a variety of faculty events, mostly due to his executive committee position in the Law Society, which he held for 2 terms. He was also a member of the university debate and moot team, allowing him to travel far and wide, such as the United States, South Korea, and Kenya. Upon being called to the Malaysian bar in 2009, Mr. Raphael sharpened his skills in civil and corporate litigation at Lee, Hishamuddin Allen, and Gladhill. His breadth of practice ranged from contracts to torts, intellectual property to insolvency, and employment to human rights. Other than that, he was named as the Malaysian In-House Lawyer of the Year by the Asian Legal Business in 2014. So without further ado, let us call upon Mr. Raphael Koch to explain some tips in understanding mood problems and how to draft a memorial. Please welcome.
Morning, everyone. I hope I'm audible enough. I'm trying not to use my headphones. Thank you for the introduction, Abigail. I'm not sure where you get that resume. It's longer than the one I gave you all, but thank you very much. Covered my life story more than I wanted to disclose. So before I begin, let me just briefly explain the structure of my presentation. Structure, as I will explain, it's very important. So I have some slides, but I understand that it may be difficult to show you too many slides. My device is not the greatest. So I'll devote just about 15 minutes to quickly go through some slides. Don't worry, it's not too many. It's not 50 or 100, perhaps some of you may be accustomed to in your lectures. Very brief slides, but the slides are quite important for me to drive home several points, because this is being a memorial session. I would show you some templates so you have a better idea. The second thing that I also want to mention is that I'm aware that my session is meant for memorial, but I'm also expected to talk about research. It's a bit difficult because I need to show some specific examples, and research differs across mooting competitions. So in my main presentation, I won't be touching about research too much, but I'm happy to deal with them in the Q&A. So I'll spend substantial of my time actually at the Q&A part. So feel free to ask me questions. You can even ask me questions as my presentation is going on by putting it in the chat, so that's not so disruptive, and it's smoother that way. I will also take up some questions that some of you have given in advance. Questions, I'm a bit confused. I believe the questions should be in relation to the second session, but I also see some questions about advocacy and research, but that's fine, because ultimately memorial is tied to research and advocacy. And in an ideal situation, I would have liked to have a longer time with you where I can explain the entire life circle, which is from research to advocacy, because they're intricately intertwined. But unfortunately, that takes up more than 15 minutes. So I'm unable to do that. So I will begin with my presentation. I will share my screen. Hopefully nothing goes wrong. Can you all see my screen? Okay, good. So I entitled my presentation as How to Write a Top Memorial. Okay, it's not. Okay, good. I hope the slide has moved. Okay, so I'll be talking about three things. Like what Sahin had said, structure is very important. So right at the outset, I'll tell you what my presentation is about. Three things: structure, substance, and style. Of course, these are just guidelines. These are not hard and fast rules of how to write a top memorial. So just bear in mind that. So structure. There are three basic rules. Three basic guiding principles, which is you have to be systematic, you have to be succinct, and you also have to be stylistic. Very quickly, what this means is systematic means your structure should have ideally a logical flow, especially when it comes to memorial drafting. It's slightly different in advocacy, because in advocacy, you can have the flexibility to switch the structure of your submissions, because some judges prefer like you put your strongest argument first. And your strongest argument might not be the first argument in the sequence. It might be, if your logical flow is A, B, C, your strongest argument might be C. So when it comes to oral presentation, you might start off with C. But when it comes to memorial, you have to be a bit more systematic. For example, if the mood problem is about tort, negligence, and you have 3 points to make on existence of duty, breach of duty, causation, you have to follow that flow. You cannot start your argument with causation and then work backwards. Okay. So that's what being systematic means. Succinct, this is something I'll talk more in style, but it's very important to be succinct even within your structure. The test for me, which I like to tell some of my mooters, is that, see, the index, I think you know what an index is, but never mind, I'll show you an index. The index is usually what I would like to see from my mooting teams. And the index should be self-explanatory. I look at the index, and if I'm a memorial judge, and I've been a memorial judge, when I see your index, I should already understand what your submission is. That's how good your structure vis-a-vis index B. And you have to be very succinct. You have to use the right words. And as what Ashraf has said as well, you have to be simple and direct. And the last thing is stylistic. This is something very important as well, but due to the shortage of time and the presentation over Zoom, it's a bit difficult. But stylistic means the formatting, the aesthetics of the memorial. And I say this not just for memorial, but I say this also for your assignments and your submissions, course papers when you become a lawyer. So I should have said this from the outset, but I'll say it now. What I'm teaching you, or what I'm telling you now, is not only true for memorial, for mooting purposes. Of course, that's where the focus is, but most of what I'm telling you is also relevant when it comes to all kinds of drafting. Your assignments, maybe your even written tests, and of course, your course papers, submissions when you practice as a lawyer. So style is very important in terms of your formatting. Especially you have to look at it from a perspective of the examiner, the reader. If the submission's a mess, if the formatting is all over the place, it's, you don't create a good first impression. And frankly speaking, you can even piss the reader off. So style is very important. And that's why you see the style of my presentation. I'm not the greatest PowerPoint creator as well, but I put some effort into making it very simple, not too many texts, and also the formatting. So this morning I actually just changed a little in the fonts, the structure. Where you see the structure, the word structure, actually use small caps format. It's a subtle, but it's very appealing to look at. So instead of using, like you see 1, 2, 3, be systematic, succinct, be stylistic is the normal kind of fonts. But structure is using small caps. Small caps basically means your capital is a big cap, and the non-capitalized letters are actually still caps, but smaller caps. So for headings, it actually looks really, really nice, And a lot of top memorials use this kind of soft, small, subtle style. So let me give you an example, so you know what I'm talking about. So I'm giving you an example from one of my team's memorial, and they won the memorial prize, the international rounds of prize media law moot in 2019, which is 2 years ago. So this is their index, or an excerpt of their index. So it's succinct. You can see a systematic flow to it. So For example, A and B, there's a logical flow for it. So the first issue is whether there's an interference of privacy. The second issue is that, okay, if there is an interference, was it lawful or arbitrary? So you cannot put B above A, this is the logical flow that you have to follow. So it's succinct because it's short enough, but it's straight to the point. And it also highlights the key words, like for instance, further down, you would see the word public interest. So when it comes to privacy versus freedom of expression, public interest is one of the focal point, and especially during the advocacy hearing itself. So that word should appear even in the index itself. It's that important. So that is what I mean by your structure, your index has to be succinct, has to be comprehensive. That when a judge reads your memorial, even at your index, he already knows, oh, okay, I know what the submission roughly is, and yeah, I think they're on the right track, So structure is very important. So moving on now to substance. As you know, when it comes to substance, there is the law, there's the facts, there's the law, and also arguments, which I like to call it as logic. So I won't spend too long on the law, on how to do good research and all that. So on this point, I'll just briefly show you the template of the same memorial, so you can see how the law is stated, how the facts are spun, and how you use logic in your argumentation. So usually you should start out by stating the law in every argument that you make. And I'm talking about memorials of an international standard. You have to be very precise on the law. So look, this area of law is a bit specialized, so I'll just quickly explain. So there is this very interesting landmark decision called Google Spain and Mario Coseja. It's about the right to be forgotten. It basically means that you have the right to remove information about yourself if you feel it intrudes to your privacy. So hypothetically, okay, touch wood, if not so appealing or embarrassing pictures of you appear on the internet, posted by your friends or someone who doesn't like you, your enemies, you have actually the right to ask website operators, search engines to remove those personal, private, intimate information. So this is what this case is about. I'm giving you some context because the templates that I'll use is on the same case. So it's important to be precise because this case is actually not on the recent EU GDPR. So GDPR, I think most of you have heard about it, is the latest regulation from the EU. But actually this landmark decision is not on the GDPR. It was interpreting a prior directive, which was non-binding. So I'm just emphasizing how when it comes to stating the law, it's quite important to be precise as well. So perhaps to use an example in IHL, like what Ashley is experiencing, you have to be very careful. When you cite a case, you have to identify whether it's the ICC or the ICTY. And it can make a difference because if you're citing a case from the ICTY, it's interpreting the ICTY statute, which may be slightly different from the Rome statute. So precision of law is very important, especially for the memorials. You might not run into this problem when it comes to advocacy, but you may find a judge who knows the law And if you just misspeak, or if you misstate in a memorial, oh, Google Spain concession was about the GDPR. No, that is wrong. Okay, let's go more into the facts and logical arguments. So what I mean by spinning the facts is, of course, not misrepresenting and misleading the facts, but using the facts in your favor. Of course, this is easier said than done. It's hard to explain without you knowing the mood problem and I showing you. But I think a simple thing that I can say is that spinning the facts means the best way to spin the facts is to use a fact which seems to be against you, but to use it in your favor. If you can do that, that is simply amazing. And actually, if you think hard enough, you try hard enough, it's something you can do in your submission. So just using this example, public interest. So this memorial, it's for the applicant, which is the person wanting things to be private. So he has to rebut public interest. And so like the first paragraph, he makes this submission, which is logical, but this gives a different spin to it. And it is that not everything about public figures is in the public interest. And this carries through throughout the submission. So like politicians, issues of corruption, yeah, maybe of public interest, but your private, intimate life, your affairs and all that, yeah, they may not be of public interest. So public interest may seem to be a point against the person protecting privacy, but you can spin it in your favor to show that the information is really not relevant. And you can see from first point, second point, how you spin the facts is to try to distinguish between private information and what is of public interest. Okay, so now it's the more exciting part. It's about style. And actually these points have been mentioned by Ashraf as well. And it is true for memorial. You have to be strong, assertive, you have to be simple, express your words in simple language in as few words as possible, and to be seductive. The last point I'll explain more later. So I'll focus more on points 1 and 2, what it means to be using assertive language and simple language. The best example is this basic drafting rule. It applies again, not just for memorial, but all kinds of writing. As much as possible, use the active voice and not the passive voice. So examples of the active voice are in red on the left side. Let us meet on Zoom. Passive is the meeting will be held on Zoom. Active, she breached the contract. Passive, a breach of contract was committed. So why the active voice is usually more advantageous? It is more direct. I mean, you can see that it's more impactful. It's also more assertive. And lastly, it's comprehensive. See, the slight problem with the passive voice is that it can leave out the subject. It can leave out key information. Like you look at the second example, a breach of contract was committed. You can write a sentence in passive voice and still exclude an important piece of information, which is who breached the contract. So more often than not, when you force yourself to phrase a sentence in the active voice, it will usually contain all the necessary information. She breached the contract. The same as the first example. See, the active voice requires there to be a subject. Let us meet on Zoom. So when you use the passive voice, not only it's longer, not only if it's less assertive, it's also unclear and more ambiguous. So as a general rule of thumb, try to use the active voice. There are some exceptions, of course, but it's a bit technical and all that. But the general rule, when it comes to drafting, your structure, your arguments, use the active voice. Okay, here's a bit of some fun. Okay, here's a brief exercise. I want you to take some short time. I want you to shorten this sentence that you see up here. So the sentence that it is reads, okay, it's a lot of words. It is respectfully submitted by applicant that a grave mistake has been committed by the respondent in relation to this issue. Just take like 20, 30 seconds, just try to shorten it as much as possible, but preserving the gist of the sentence, and of course not leaving out unnecessary information. And you don't even need to use different words, like find a synonym or anything. Just try to shorten it, cutting off the words that are right there. And yeah, see how far you can shorten it. Okay, so oh, okay, good. You can post it in the chat if you want. Sure, that's great. I didn't expect that, but okay. So answer A, it is the applicant's respectful submission that a grave mistake has been committed. Okay, it's as long as the real sentence itself. Not so good. Okay, B. Oops. The applicant respectfully submits. So you're getting there, you're using the active voice already. So the original sentence, it is respectfully submitted by the applicant. That's the passive voice. B, the start line is the active voice. The applicant respectfully submits. That is active. But unfortunately, the second half of the sentence is still using a passive voice, that a grave mistake has been committed. So not so good. Even shorter. We submit that the applicant has committed a grave mistake on this issue. Yeah, I mean, you are the applicant. You can describe yourself in, the first voice. You don't need to refer yourself as a third person. Yeah. Slightly different, but they can be slightly more impactful because you start out by saying that, okay, on this point, we submit that respondent has committed grave mistake. And lastly, if you got C and D, you're good. But of course, my personal preference is E, purely for stylistic purposes. And E also kind of uses semi-passive voice, but it is probably the most impactful, if not the most formalistic. So this is what I mean by switching from the passive voice to the active voice, but that is just merely a means to an end. Ultimately, the end is to make your sentence as impactful as possible. Usually that means using the active voice, but using the passive voice can deliver as impactful or more impactful message. Yeah, go ahead. Just like eat. Okay. So good efforts by some of you. And look, this is something which is useful not only for your memorials, but for your assignment and your tests. You know, assignments, you have a word count limit. Tests, you have a time crunch. So the less words that you use, the less you write, but delivering the same content, the more effective and the more you can write. So so it's a very useful skill to have, to be succinct, to be direct. It saves you time and it allows you more time and space to say more. Okay, I guess that's the end of my presentation. I will take some prepared questions. I will stop sharing my slide. Yeah, I'm looking at the chat. Well, some of you have great examples. M3, M66. Well, all of you basically have great examples. But don't worry. It's drafting. It's something that you cannot change overnight, or even over a week or over a month. It takes months of practice, sometimes even years. But I know cliche as it sounds, you know, practice makes perfect. So the sooner that you start, you know, better you get, sooner rather than later. Maybe before I take on questions from the chat, how much time I have? 11:30 is when I on. Okay, we have 20 more minutes. That's good. I'll just take one question from the advanced sheet that I got. Is it, okay, I'm reading it verbatim. Is it bombastic word will become an added benefit for the submission? My answer is yes and no. I'll start no first. Memorial judges or lawyers or judges, real judges, we are not really impressed by flowery language. This is not a essay writing competition. It's not a poetry writing competition. But there are some baseline expectations that you should use grammatically correct language and you should use precise words. And this is where the yes comes in. Sometimes you have to use bombastic words because it is the most appropriate and effective word to use. For example, there is a fundamental difference between termination of a contract and rescission of contract. So if you use the words interchangeably, wrongly, then you might run into the problem because the judge might be confused, or you might be stating the wrong position in law to support your arguments. So that is why sometimes you have to use precise language in law, which are bombastic in nature. Unconscionability, estoppel, even getting away from purely legal terms. This is another common term that lawyers like to use and like to hear. And if you can use it in mood, it can impress them. Blowing hot and cold. So blowing hot and cold is an idiom. to mean you're contradicting yourself. You said A and then now you say B. So, I mean, I'm not sure whether you can term that as bombastic words, but the point being is that there are certain words in mooting, in legal practice, that will help push forth your arguments and to impress the judges when you use them. So in a sense, yes, it is good to use bombastic words, but only when it serves a purpose. Don't use bombastic words for the sake of it. Like, don't start your submission, not don't, but it's a bit odd to start your submission quoting from Shakespeare, unless it's really relevant in a particular case. Okay, maybe I should take some questions from the chat. Okay, I'm trying to scroll up. Okay. Okay, there's one question in the chat. Sorry if I miss any. I have a question. Does drafting either submission assignment must be necessary? Okay, about the active voice. Again, what I've told you previously are guidelines. When it comes to memorial or your assignment, at the end of the day, it also depends on who is the audience, who is the lecturer marking your assignment. And if you're talking about memorial, is it a national competition? Is it an international competition? Because it makes a difference. Different audience have different standards. They may even have different expectations on how colloquial or how formal you can be. Is like a senior lawyer, senior judge, then yeah, perhaps you should be more formalistic, and that means using more passive voice or not excessively using the active voice. Let me give you an example, which is actually more true to advocacy, but it's still an example. So in Malaysia, we follow common law, UK. So our practice is, to put it nicely, we are more traditional, more conservative. So we have to be extra polite, decorum is important. So lawyers like I can't say for certain. And unless if I'm coaching you, I would say, yeah, perhaps err at the side of caution, be more formalistic. So again, yes, you have to, it depends on your audience. But that's why I'm talking about when it comes to international standards, memorial, you have to think about out of Malaysia, and words like it is humble submission and all that, it's not going to carry any impact, and it's only going to waste words and time if you're submitting orally. Okay, next question. In a mooting competition such as Jessup, where there are a number of complex issues, how can teams ensure that they cover all issues in depth and comprehensive as possible? Okay, this is a very tough question. So if you are doing an international moot competition, not just Jessup, but even IHL, international arbitration like this, or even competitions, semi-national, international competitions like law issue, the issues can be quite complicated in the sense that, it's multi-jurisdictional. You're not just looking at the laws of one country, constitution of one country, but, you have to look at state practice. Yes, it can be really complex because sometimes even the legal issues are not settled. There's a school of thought A, there's school of thought B. For those who are familiar with international arbitration, the whole Sula America test is going on and on. Recently, there's Enka and Chubb, which hopefully has settled the test, but there's so much academic scholarship. So in Jessup, it's a bit difficult in that sense. And sometimes issues are drafted in such a way that the issue is almost purely legal. It's not even factual. Of course, the aim is to cover as many issues, but emphasize on the strong ones. Honestly, it's a very delicate balance, between quantity and quality. Quality means focusing on your strongest arguments. Quantity means covering as many issues as possible. The difficulty is that, different judges have different preference as well. When I say judges, I mean memorial judges, but also, judges in the oral rounds. Some judges would give you more points if you know a lot of things. So you need to cover everything. Some judges prefer that you give your killer point, okay, just give me one good argument. That's all. I don't need to listen to anything else. So it's more difficult in advocacy, of course, because judges, kind of fluctuate. But I guess when it comes to memorial judges, most of the time memorial judges are experts in the field. So they would have an expectation that you cover as many issues as possible. But at the same time, for your submission to stand out, you need to have cutting edge. And the cutting edge is to be succinct, focus on the strongest arguments. So maybe I would sum up this answer by saying that the quantitative part, which is covering as many issues as possible, is the floor being the minimum, whereas the qualitative part, focusing on the strongest arguments, on creative arguments, is the ceiling. Yeah. So what that means is that, you should first focus on the floor, the fundamentals, which is covering as many issues as possible. If you've done that, then yes, you can focus your strongest arguments. And I'm speaking purely in your memorials. When you're talking about orals, yeah, you don't have to, I think what Ashley has said, especially if you're a respondent, defendant, you don't have to say everything. If there are 5 elements, you can just go up and, Your Excellencies, I'll only be disputing the second and necessity or whatever. But yeah, in memoirs, unfortunately, you have to be more comprehensive. All right, I don't see any more questions in the chat, so maybe I'll take another question from the advanced list of questions. Or does anyone want to speak up?
Hello, I have a question.
Yes.
This is purely out of like curiosity. In the memorial, when you had stated just now that the substance, we should firstly start by stating the law, but then in evaluating law, for example, in competitions that revolves around international law, so how do we rank those the law, i.e. which comes first? I mean, after the treaties, which law is the most important that we should lay down first?
Sure. That's a very good question, and I think the simplest answer is that you have to bear in mind that there usually is a hierarchy of laws. So if you're talking about, say, a constitutional issue in Malaysia, yes, you start by the constitution. International law is a bit tricky because technically speaking, there is no hierarchy. If you're talking about, if you're talking about IHL, there is a hierarchy in the Rome Statute, so you have to follow that. And certain specific regimes of international law already provide a hierarchy. But if you're talking about international law in general, there is strictly speaking no hierarchy. Article to this, the ICJ statute, custom treaties and all that, even though there's a list, I mean, of course, some scholars say that that is a hierarchy, but consensus is that it is not a hierarchy. One rule is not superior to the others. But as a matter of practice, generally, if you're talking about international law, you should start with treaty. Treaty is like your contracts between countries and all that. And if there's no treaty, then only you look at custom as a matter of practice law. But strictly speaking, treaty and custom carry the same weight under general international law. And of course, judicial decisions, national court decisions, you have to bear in mind they are only subsidiary means to identify custom or interpret treaties. So in international law, it's more of a civil law model. Case law is not as persuasive as a common law kind of jurisdiction, but that is the strict position. But then again, as a matter of practice, a lot of international courts, including the ICJ, refer to their previous decision. There's no stare decisis, but they have said that it's highly, more or less highly persuasive. I believe it's the same as the Rome Statute as well. If I'm wrong, maybe Ashley can correct me, but yeah, there's no stare decisis. The decisions, previous decisions of the ICC, ICTY, National Court decisions are not binding, but they are persuasive in interpreting the Rome Statute or the elements of crime, etc. Maybe I can add something here. I know this is adding some trickiness, difficulty. There's also a difference in expectation between civil law judges and civil law practitioners and common law practitioners. Common law practitioners, they are more happy, they appreciate to hear case law more, whereas a civil law practitioner, if you encounter them in an international mood, they may not be too impressed, they may not be persuaded by case law, they much prefer scholarship by jurists, so citing textbooks or even journal articles might be more persuasive to them. So yeah, so there are some nuances as well.
Hello, Mr. Raphael.
Yes.
I am Hakim, third year student from UCM. I would like to ask about in process of drafting a memorial. Basically, there are certain limitation of words. So how as a researcher, how can we address the issue by having the certain words, or maybe how can we address the issue by not go against the limitation of words, because usually student in addressing the issue, they often explain about something is not relevant or not concerned about the issue. So maybe you can have any answer about that.
Sure. I think there are two methods to it. One method, which I personally find quite impactful, and probably other judges and lawyers as well, is if possible, you should try to quote as much as possible from the cases, the actual words. But of course, you need to put it in quotation marks. This is true for assignment, otherwise you'll be accused of plagiarism. So as much as possible, you can cite directly from the cases. But of course, sometimes the passage is too long and all that, and the skill comes in, kind of shortening it. I think you learn this in, legal method or research methodology, but there's a method to kind of shorten like a long paragraph, using the three dots and all that. The second method is, of course, to paraphrase using your own words. Of course, that's impressive as well, but there's a danger of misquoting or misleading if you paraphrase something wrongly. And I think as a memorial judge, and perhaps the more subject matter experts, a more critical one, they can be a bit annoyed if you use a shortcut. So that's why I gave that GDPR example. If the memorial judge is a privacy expert, if you had said, put in your memorial, see that part in the memorial, if you saw, it's like quite long, it's the CGU interpret GDPR, it interpreted the directive which replaced the GDPR. It's like, you would think, oh, so many words, why not I just say GDPR? If you take a shortcut, you might run the risk of misstating the law, and you might get penalized from that. So it can be a bit tricky. So what I can say is that this is where style and language comes in. So that's why, the bombastic words come into use, because they can minimize your words. I mean, just to give you an example, instead of saying, say if your vocabulary is not good, this is very simple example, you would say, the person said very loudly. Okay, said very loudly, that's 3 words. But if you know the word shout, scream, that's only 1 word. The person screamed. So that's a very basic example, but that's why vocabulary, bombastic words can come into good use. When you can find a word to replace 2, 3, 4 words. So that's why language is important. When I say language, of course, it's legal language, not necessarily Shakespeare and all that.
Ladies and gentlemen, if you have any other questions that you would like to ask, you may ask now. Since there's no questions, we will now proceed to a virtual photo session together. So I would like to invite all of you to please turn on your camera. All right, so please be ready. 1, 2, 3. All right. Thank you so much. Ladies and gentlemen, session 2 has officially come to an end. I would like to apologize for any mistakes throughout my duty as the MC. Thank you so much, Mr. Raphael, for your meticulous sharing on the elements in the memorial surgery research session. Truly, we believe that your profound explanation will suffice for the betterment of law students in the mooting field. On behalf of the organizing committee of National Moot Workshop, we would like to extend our warmest gratitude to our distinguished speaker, Mr. Raphael Kopp. That you all have gained as much knowledge as possible in this session. Thank you for attending. Next will be session 3, which will be hosted by Kausalya Raja from ATC. Do stay for the upcoming session to equip yourself with more knowledge. With that, thank you and have a good day, everyone.
All right, let's begin our third session now. Ladies and gentlemen, I would like to remind all of you here to turn on your camera. Okay. Announcing the entrance of our honorable speakers, Professor Dr. Juria Binti Abdul Jalil and Mr. Joshua Teh Hong Wan. Good day to the distinguished speakers, ladies and gentlemen. A very good morning to all of you here. Welcome to the third session of our National Moot Workshop program. Before we proceed, allow me to introduce myself. I am Kausalya Raja from ATC School of Law, and on behalf of the organizing committee, USIM Mooting Club will be your MC for this session today. Honorable guests, ladies and gentlemen, now let's begin our event with the third session, which is An Art of Advocacy in Court. Let's begin our session with introducing briefly the background of our honorable speakers. Our first distinguished speaker for the session 3 is Professor Dr. Juria Binti Abdul Jalil. She had obtained her PhD from the University of Exeter, England in Broadcasting Law in 2000. Prior to joining the university as an academic staff, she was an advocate and solicitor practicing in Kuala Lumpur. She has written many books and articles related to law. The most recent articles that she has published was Regulatory Control of Herbal and Traditional Medicines in Malaysia, Issues and Concerns. She also did a research on the Korean approach to online protection for children at the Seoul National University Law School. Furthermore, she had also presented her findings at 13th Australasian Conference on Child Abuse and Neglect, organized by the Australian Institute of Criminology in Melbourne. There are many incredible things that she has achieved in her career. Our next distinguished speaker is Mr. Joshua Teh Hong Wan from UUM. Mr. Joshua had obtained his LLB from University of Utara Malaysia. He was associate in sexual and gender-based violence protection UNCHR, the UN Refugee Agency in Malaysia. He is also a distinguished practicing lawyer. He is the advocacy officer at the Women's Center for Change in Penang. Furthermore, Mr. Joshua has a very vast experience in mooting, where he was the champion for Datuk Zainal Azam Mood Challenge Trophy in 2009, and for IHL national competition, which was in 2010. He was also the runner-up for the IHL Asia Pacific in 2020. He proudly has represented our country for Asia Cup Moot Court competition in 2010. He was also a coach for IHL National in 2019 and 2020. Without further delay, I would like to call Professor Dr. Juria binti Abdul Jalil as the IIUM Moot Master to begin this session. Please welcome.
Thank you very much, Ms. Chairperson. I hope you can hear me clearly. I was trying to get to my laptop, but there's something wrong with it, but never mind, we'll just proceed further. Thank you very much. First of all, thank you very much for inviting me to this workshop. The session that be given to me is about an art of advocacy in court, particularly focusing on the preparing for oral submission. Yeah. So how I will discuss this issue is I will first relate the mooting and advocacy, and then I will discuss the preparation of oral submission from 4 perspectives. And then I will touch a little bit on the answering of the judges' questions. Yeah? So I will begin first by relating mootings and to advocacy. Though I will first look at the definition of mooting given by the Oxford University Press, which clearly represent the mooting session and also the court session. So if you look at the definition, it says mooting refers to oral presentation of legal issues or problem against or problems against an opposing counsel before the judge. So if you reflect this, you'll find that in mooting competition, you have the plaintiff, the claimant, and the other party, which is the defendant or respondent. Yeah. And then both parties will appear before the judge. Similarly to the court, we have plaintiff and defendant. So when we talk about competition or court presentation or representation, we refer to the presentation of our argument, yeah, where both parties appear and the presentation is made before the judge. Yeah, of course, this will be a very scary part of the competition, yeah, but then because we have prepared it so much, you at least know what to expect, right? Now, the reason why it is carried to many of you, especially the junior mooter, is that you know that the judge will be looking at you when you are presenting your case. You know that the judge will want to test your knowledge of law, your knowledge of facts, and how you argue your case. Yeah? And the court will also assess your oratory skill, in presenting your argument, how persuasive are you, how confident you are with your argument, and so on. So basically all this in a package is to provide your ability to communicate persuasively. Yeah, so that is where it relates to the advocacy skill. Now, in general, advocacy skill means art of persuasion or art of making the argument before the court. In a manner of how are you going to persuade the judge to hear you, to listen to your argument, and to be on your side. So it's not only that the focus will be your communication skill. How clear are you in your presenting your skill? Yeah. So all this will of course lead to the needs for a good preparation. Now, as regards to the good preparation, I will discuss this from 4 perspectives. One is you need to understand the component of your oral submission. So this will give you a good preparation, because once you understand the component of the oral submission, then you'll be able to present your case or structure your argument well. Second, we'll be looking at how then, once you have all this structured well, how do you manage the presentation within the specific time? Because in mooting competition, of course, time is allocated and you have to strictly abide by it. Yeah. And then from the third thing, I will look at the importance of practice and research. This is a very important preparation for your oral submission. Yeah. And then the last is how do you prepare your state of mind to make such presentation? So I will first go to the understanding of the component of the oral submission so that you can present a good and structured argument. So if you look at it in general, there are three things in the oral submission. First is the introduction of your case, yeah, and yourself to the court. Second is the presentation of the argument, which is the most important here. And then the third one is the conclusion of the matter, all right? So you need to know what to put or what to present or what to tell the court when you introduce yourself to the court, to the judges, to the bench. This is very important. Yeah. So once you have this in mind, then you know how to address the court properly. So here you need to know, because we have so many types of mooting. So address of the cast, you need to do it properly, whether you should address them as Your Excellency or you need to address them as Your Honor, Yang Arif, and so on. Yeah, because it's the panel of judges there. Very important for you to address them properly. Sometimes in an arbitration, you address them as the panel of arbitrators. So you need to know who are the judges, who are you going to talk to. Those are very important, right? So that's why take note, prepare, because I think from the very beginning, you know already which mode are you going to enter. Is it an arbitration? Is it a JSEP? Is it a VIS mode or commercial mode? Yeah, because you need to know who are you presenting your case before. And then you need to introduce yourself. So do not take too much time introducing yourself. You need to be precise, concise, direct to the point. At the same time, you should be humble. You need to introduce yourself, your co-counsel, and which side you are from. That is very important. And then you need to introduce the other party. All the time, be respectful. And then you need to know the manner as well and how you. So all this preparation or understanding of how you're going to present will help you a lot. Yeah. So so that when the day come for you to present, yes, you stand directly or you sit directly, looking at the court, looking at the judges, yeah, and then start with a proper, good, clear voice. Those are very important. And then, of course, in the introduction, you need to know that you need to give a brief opening speech. What is your case all about? So these are very important so that the court will want to listen to you. Remember, when in this introductory part is where you introduce yourself to the court. Yeah, the court is so eager to see how confident, how good are you. So you need to project yourself well to look and appear confident. All right. Of course, for junior mooters, this is the most difficult moment, isn't it? Yeah, your leg will be shaking and everything. Your hand even will be shaking. But that's fine. That's why sometimes we ask you to, if your hand is shaking too much, just hold on to the table or the rostrum. Yeah, because we understood, as judges, we understood, but we just want you to make yourself comfortable and talk to us, right? So those are the important things. And in fact, brief opening speech will actually open the door of the mind of the judge to know what are you going to present to them. This is an important guideline. But many of you will just start with what the issue to be addressed. No, focus on the important thing of opening speech is for you to tell the court, this is what I'm going to present today. This is what happened. This is what happened to our client, for example. Yeah, our the parties that we are presenting. So highlight to them, so that from here, then the court will want to listen to you. So you need to have a strong, impactful, and informative opening speech so that you can attract or capture the attention of the judge. Yeah, and then the other thing in the introduction is how you are going to deal with the issue. So your first counsel will be talking on what, your second counsel will be talking on what, and the time limit that you are allocating. So those are very important. If you look at it, there's so much to say in the introduction, but you should only allocate like 2 minutes, should not go more than 2 minutes, yeah, of your time. So these are very important because the bulk of your presentation will be on the presentation of your argument. This is the most crucial part, all right? So when you talk about presentation of argument, the focus would be you need to be persuasive because the judge will be listening to you. That's why your opening speech and the way how you handle or you deal with the matter will give the guide to the court to listen to you. So now you need to, once you have gained the intention of the court, then you need to start your oral argument. Yeah. So the focus will be on the relating to the specific issue that you want the court to hear you. And then with that issue, you need to relate it to the relevant facts. You must be well-versed already with the facts, yeah? And those are the important things. And then, of course, the law that governs it. Yeah, so you need to strategize it well, structure your argument well, and then apart from highlighting the issue, the main facts, the law, the application of the law is very important. So you'll find that this presentation of argument are so important to your oral submission. Yeah, this is where you'll be expecting the court to ask you a question, lots of questions. You are then looking at the judge to see whether the judge can understand you or not. And you will find some judge who just have a blur face, so you don't know whether they understand or not. But the other judges will show an understanding, so you're a bit confused. But basically, just focus on it, just go on with it. Because if the judge do not understand, they will ask you a question. All right, but remember, clarity of presentation is very important. So don't flip through your notes, don't use your hand gesture too much, for example, and this is going to be distracting. Yeah, so the important point in this part is the structuring of your argument. Yeah, and normally you will put your strongest point first. Yeah, now there are some mood master would just or the trainer will ask you to focus on three things. That there's a 3F, they call it: fight, focus, and then flag. So the fight means you identify the spectrum or issue of your mood problem. What is it that you are going to present here, and on what aspect of this issue that the other party is contending. All right. So remember, these are where you present your legal argument, and these are the method that is contended by the other party. So you need to make sure that you structure it well to the fact that when you present the issue, you need to highlight the facts that relate to it, and then you apply the law to it as well. And then at the same time, you respond to the other party's allegation or contention, and then you sort of like tie it in the sense that what they say is basically not prevail, but what we're saying is the truth. All right. So those are the important thing. And then yes, the substantive issue, because in arbitration mode, you have to be very careful because there are procedural issue and there are substantive issue. But again, those who are focusing on procedural issue, for example, highlight the main issue. And then for a merit issue, you need to focus on the merit issue that is being contended by the other party. The focus again is to prove your case. All right. So those are the very important things. And of course, your argument must flow very well. All right. This is not an easy thing to do, especially when there is constant interruption from the judge. Yeah. So that's why I will discuss further when you on the preparation, on the state of mind. Yeah? Later on. And okay, now the main preparation for this part of the oral argument is you must understand the issue very well. You must understand the facts, yeah, because remember, if in JSEP there are quite the facts are about 50 to 60 paragraph, yeah. So you need to know which one is relevant to your argument, yeah. And then that is why it's also help you to remember to use your trial bundle. You tag it, yeah, so that you know which is the relevant provision to refer in relation to fact, which are relevant cases for you to quickly refer to, yeah, in relation to your case, and then to the legislation. Some you will use color coding as well, so that you can strictly go to that aspect when the judge, for example, asks you certain question, or if you know it by heart, then you just looking at it, you know already, the judge is questioning on this. Yeah. So these are all the important things. So the focus is the most important thing there, whereas the flag is basically using signposts to guide the judge to your argument into that matter. That's what we always ask you to do. Give a signpost. How many submission have you got? How many sub issues have you got? Yeah, and when you are done with one issue, when before you go to the other issue, you tell the court, I'm now referring to going to discuss on the second issue, the fourth issue, and something like that. Yeah, so those are the important things. Yeah, so the first two, the fight and the focus, you need to prepare it from the very beginning already. And in fact, you have started preparing in when you prepare the memorials. Yeah, but remember, memorial takes a long time. But now you have to condense all your argument into how many minutes. That is the worst challenge. You know, the worst time when you are presenting is the worst challenge is that the time is your worst enemy. All right. So that is why you need to make sure that all are interrelated together, you can serve a good package to the court, right? So the third component of the oral submission will be your conclusion, right? So you have informed the court what is it that you're going to do. You have discussed your case, you prove your case already, and now you want to make a conclusion. So how should your conclusion? It should be impactful conclusion. Relate back the facts. Bring the case that you have proved to prove it. And then from that, you conclude by saying, therefore, the court should allow your claim or should not allow the other party's claim. Right? So these are the important thing. And of course, these are the bulk of it. So if there is a 15 minutes, so 2 minutes for the introduction, the bulk of it, to the argument, and then the 2 minutes for the conclusion. So then it will give you a good package, right? Right. So once you have all this, these are all clearly there in your mind. But now, how do you prepare it to make sure that it is within time? As I mentioned earlier, the time is your worst enemy there. All right. So how do you manage your time well so that you'll be able to present your argument within the time limits? Sometimes this is most difficult too, because especially when there is a constant interruption from the judges. All right. But in competition, your time management is also being assessed, right? So that is why, how do you prepare all this? So as we know that 2 minutes for this, 15 minutes or 13 minutes for this, 2 minutes for conclusion, that should be it. In other words, allocate your time well, all right? And then, but of course you need to exercise flexibility as well. As you go through, you will know that how much time has been taken by answering the judge's question and things like that. But of course, some of the judges may be very generous, because if they take a lot of your time, they will give you some extra time. So don't worry about that. But try as much as possible to make your presentation precise, concise, and direct to the point. That is very important. So that is the next keyword. Or you need to always be precise. What does precise mean? You need to be accurate. You need to be exact. You need to be correct. So if you are referring to the facts, which paragraph is it? And then what are the exact or the provision that govern this matter? Right. So those are very important things. So precise mean, again, accurate, exact, and correct. Because some of the judges may know the case very well, may know the law thoroughly well. So that's why you need to make sure that what you are saying, what your reference that you make to, is to the correct provision, for example. Concise means once you have all those, you need to briefly and clearly explain to the court. This is one of the most difficult challenge, because most of us will tend to elaborate and go around and around and things like that. So you need to just go direct to the point, make it clear to the court. And then, yes, the next is direct to the point. In other words, straight to the essential point. So you need to be precise, correct. You need to be concise. You need to clearly express yourself so that the other party could understand. Make it simple for both parties. And then go straight to the essential point. Now, the other thing that you need to do here in relation to manage your time is you need to train your line of thoughts. You yourself know how. So you need to train your line of thought, your line of thinking. So how do you approach this matter? All right. So make it use a simple language. Simple language could help you a lot of things. Could help you to read the point clearly and be understood by the listener. All right. And yes, you need to always be aware of your time. And there are times during the competition, you find that before you can answer or before you can proceed further, the organizer or the court bailiff there will just tell you, or you have only, or your time is up. So if you saw that, you need to stop your submission and ask for the court time, or tell the court that your time is up. But if you can ask for time so that you can conclude it, right? But always do it in a humble manner, okay? So the next thing is, yes, practice and rehearse your oral submission. This is a very important preparation for you. Why? Because you don't want to be seen reading. When you have a lot of practice, you rehearse all the time, it's already imprinted in your mind what you want to say. All right. So remember, in oral submission, don't look at any script. you should not be looking at any script, because looking at any script, it shows that you're not confident with your submission. But of course, a glance through it, it's fine. But I know that some of you are not actually reading, but it's a habit to look at. Yeah, so that is why you need to control your eyes to look at the panel of judges. But actually, there are times that you don't have to look at the eye. You look at something else to make you focus, as if you're talking to them. Yeah, so those are the very important things. But again, practice and rehearse will help you a lot of things. Yeah, for example, to get the right rhythm of your speech, you don't want to be speaking too fast. Yeah, and then you want to use the right tonation to express, yeah, your argument well, to express your case, or your persuasion to the court to hear you, for that matter. Yeah, and then also when you practice and rehearse, you have a time to find or choose the right words to use. So that is very important, because there are times when during the competition, suddenly the word lost. You don't know what to say, how, and then you start grabbing for some word which is not actually directly to convey your meaning. All right, so that is why practice will help you to find the right word, and you're comfortable with using the words. Yeah. And then, of course, during practice, you'll be practicing before your colleague or before your trainer. Then, of course, your trainer will definitely ask you to look at you. Don't look at the script. Look at the face. Talk to us rather than read to us, because when you're reading, your tonation will be very flat. We don't want that. It's not convincing at all. In fact, it will be very boring to the judge, right? So when you look at the eyes, you can see the expression. And it's very satisfactory, actually, when you find that when you're talking, the judge listening, the judge is able, the judge will just nod the head and say, okay, you know, and things like that. That is very reassuring, actually. And you want to contribute further. You want to say further. But of course, you have to know that you have a time limit there, yeah? And then if possible, you need to try, and where possible, and in fact, if possible, in case this is a requirement, if you can put your submission within time, that'd be really good. All right. But of course, with introduction of the judges and so on, it will be kind of difficult sometimes, but you need to be able to maneuver, manage your time well. If the judges are asking your question, a question that you are going to discuss later, then you put in your question so that you can save time on that. They're related. So that will be good for you too. And all this will be more helpful if you have practiced it. Yeah, you rehearsed it, so you'll be able to have a control of your time, the control of your mind as well to the. And then the other thing about practice and rehearse is the question that the trainer or your colleague gave to you. Yeah, sometimes these will be the question that will be asked by the judge. So that will be a good point, isn't it? Because if the trainer asks you this question, and during the submission, the judge asks the question again, then of course the judge can see, because you smile at it, you know, you can automatically say, I know the answer to it. But then be very careful. All right, be very careful. Strategize your answer well. Make it a good package, so that when you give a good answer, the court will not ask you any more questions. But if you give an answer which is not sure, then the court, you are inviting the court to ask you more questions. All right, so be very careful of that. So these are the things that makes practice and rehearse very important to you. I know that most of you will be practicing, will be doing that. Yeah. But it's just that when the time during the oral competition, yes, anxiety, all those feelings that come about. But again, have control. Yeah. So that is why the next point is prepare your state of mind is very important. All right. So remember, you have been dealing or doing the question from the very beginning, 2-3 months ago. You know the facts very well. You know the law. You have research on it. Yeah. And in fact, remember, most of the judges will not know the law, the facts as well, but they are just relying on you to see how you can present and make them understand about right? So, and, um, yes, some judges will ask questions because they are required to, because to assess you in is your knowledge of law, to test you, because they have to give you marks. So to think why the judge asked you question, right, is basically to help you improve yourself, to make you better in your learning the law in your future career later on when you appear before the court. Yeah, so that is why you need to think positive, because the reason why. And then yes, you need to think positive of all the competition. You need to when you think and then you need to also tell yourself, yes, I can do it, I can do it. I've been doing it since 2 months, yeah, 3 months, for example. I know all this, I've prepared the argument myself. Yeah, all those things. Yes, you need to reassure yourself, tell yourself that yes, I can do it because I've labored myself on this. All right, so it always will woo the judge with my presentation. So those are the important things. Yeah, and then always remind yourself, you're so scared of the judges, the question and so on, you always remind the judge that you always remind yourself that judges are there to assess. Not all of them. When most judges are basically there to help you, actually. In other words, that they do not want to be purposely hostile to you. All right, because the purpose of that is, again, to test your ability, to see how good you are. And in fact, the judges could be your potential employer, all right? Because some of the judges, pick up their the student or their team student from their performance in mooting competition. Yeah? And that is why you need to take the opportunity to be able to convince the court. So you don't have to be afraid of them, but get opportunity to convince them, all right? And most of the time, if you look at the question, it's just to make sure that you are sure of your argument, yeah? And also the rule of thumb in court, for example, the judge should not interrupt unless the court want to seek for clarification. So that is why the court asks questions, yeah? Sometimes the court find that you did not answer, or your submission is not clear, so they ask questions so that you can improve on it, yeah? So those are the reason why the court the judge ask you question. But always remember, you know it, yeah. But when you let the fear, yeah, prevail, all right. So always remember, the focal point is understand what the judge is asking. All right, take time to understand what the judge is saying, and then once you are able to understand, then we will be able to plug in all the right question in the right answer in your mind, assemble it together, and then present it to the court. But if you did not understand the question, then you can always humbly ask if the court may rephrase the question, for that matter. Yeah, and so these are the important things. Okay. And then if you face difficulty when you during your submission, what you need to do is take a short deep breath, but don't show it that you are taking a long breath. Just take a short breath to compose yourself, because you want to let the oxygen come into and help you to think, to compose yourself. So that is very important, because you may want to ask for a moment of your time and to use that moment of time to actually make yourself compose. Then you'll be able to see things clearly and then present your package. Yeah. So those are the important things that you need to prepare your state of mind. So my last will be on the answering question. But remember, when you submit yourself to mooting competition, you are not only going to present yourself, but you are also need to answer the judge question. So you already know that, right? Then so the ability to answer question will determine the outcome of the moot, particularly if to determine the best oralist, for example. Yeah, so the court will look into how you answer these questions. Yeah, and then so from the question, yeah, you most of the question by the judges have some some meaning to it. Sometimes the judge would want, because they just like your argument and want to know further, so that's why they ask you question. Sometimes they give you a chance to explain or better and clearer. And then also sometimes they just want to test your understanding of the law, yeah, of the facts and how you integrate both together. And then again, as I mentioned earlier, you need to understand the question very well and seek clarification if you're not able to answer. Now, once you have given a chance, once you want to answer, you should give a best possible answer, yeah, so that the judge satisfied with it and stop you from asking more questions. And you need to also give an honest answer, because there are times when you don't know the answer to it, then you tell the court, my apologies, I'm not able to assist the court on this matter, yeah. But rather than just giving a wrong view, but if the question from the judges, if you can identify there's some misunderstanding about the court, yeah, about the question from the judge, then you clear out the misunderstanding, tell them on that matter, point it out to them. What are the misunderstandings, but in a very polite manner, all right? And then there are times when the judge wants you to concede to certain facts, but you are saying you cannot concede. But again, look at it in a manner that perhaps you may concede a little to that fact, but not to the other, so that you still tell the court our position is this. Yeah. So, and you may also want to highlight the difference between the certain case. For example, when the court says, "Oh, that case is mentioned that case. What about? What is your response to that?" So you may highlight. So in other words, here the knowledge of authority, the knowledge of the facts, the knowledge of the law are very important to you. Okay, so once you're able to do that, then you'll be able to present a good package. So that is all for now. Thank you.
Thank you, Professor Dr. Juria Binti Abdul Jalil, for your wonderful speech. Now it's my pleasure to invite Mr. Joshua Teh Hong Wan as the Mood Master of UUM to proceed with the session. Please welcome.
Okay, thank you very much. So thank you, Prof. Chiraya. That was really quite comprehensive. And thank you to the organizers as well for having me here today. So yeah, my name is Joshua, and I'm the mood coach for UUM. And I was the coach for the IHL competitions, which we won last year and the year before. So when I speak about maybe some of the tips and techniques during submission, where I'm coming from is going to be a lot from the IHL angle, but hopefully you will find something that you can implement as well in Law Asia, JESUP, NAMCO, things like that. Yeah, because these are going to be, I think, techniques that you should be able, or most mooters should be able to apply. Any good mooter should be able to apply. And so I have 6 of them. And the first one is really like at the start, right? So when you are starting your submission, the moment when you go up to the podium, or well, now we are doing it online, so it's going to be when the focus is upon you. One of the things that I would always say is, and something that worked for me as well when I was a mooter, is to take time to calm yourself. So don't feel that you are pressured to have to start immediately. Don't rush into your submission. Yeah? For myself, what helped was that I would position my notes. And of course, this is when we could do it face to face. I'll position my notes. I will look at the judges in the eye. I would smile, and then I will begin. So you want to be able to exude a sense of control over your proceedings. So make sure that everything in front of you, the mic level, the distribution of your notes, you're comfortable with all of that, and give yourself that confidence that, okay, I'm in control here. I'm about to speak. That should help you to be able to calm yourself down. Yeah? And why is this important? Because this leads to my second point, which is about pacing yourself. one of the things that you would notice is that if you are nervous, you would tend to speak faster. And what happens then when you speak fast is that while you might be able to cover all your points, the judges might not be able to follow what you are saying. Yeah. So it's very important actually to settle on a comfortable tempo that the judges can follow and they can understand your arguments. What happens is that sometimes if you happen to go too fast, not only do the judges will the judges not be able to follow your argument, it also leads to the possibility that the judges will not interrupt you or find that there is no space to interrupt you and thus won't be able to ask you many questions. And that is to your detriment because you do want to be able to speak to the judges. Yeah, when you do want to be able to show that you're prepared to answer questions. So during your practice, yeah, a good way to do that is to make sure that you get feedback from your partner or the coach on the cadence, the cadence and the tempo of your submission. Another way you can do that is you don't have to use other people, just record yourself speaking, and then watch that back and ask yourself, is this a good pace or not? Now, how do we determine what is a good pace? What I would strongly urge you to do is to go and look up. There are numerous mooting videos online, Jessup videos, I think videos from Moots, things like that, and watch all the best oralist winners. Listen to their tempo, their cadence, how they speak, and try to adopt that. Yeah. There's also the possibility that you might swing all the way to the other end and become too slow. And you don't want to do that as well, because if you are too slow, it can get a little bit boring. So one of the ways that you can course correct, so you might be asking, yeah, but Josh, how am I going to measure my tempo during the submission itself? One of the ways that I would suggest doing that is listen to when the judges speak to you. Listen to the tempo that they are speaking, and reflect it back to them. So use it as a course correction. So if you are not able to tell whether you're speaking fast or not, then you have a comparison, because when you hear the judge speak to you, you can say, oh, okay, so that's the pace that they are speaking. Maybe I want to be able to match that pace, or if not match that pace directly, at least lower my tempo so that it is somewhere in the range of that. Yeah? So that's the second thing, yeah, pace yourself. So calm yourself and pace yourself. The third thing is about answering questions. And so it is very important to listen to the judge's questions and do not be afraid to seek clarification. Now, this relates also, it's a similar thing to the first point that I made, which is about taking time not to rush into your submission. Similarly, do not feel that you need to jump into or rush into answering questions. Yeah? If you are at all uncertain about what the question is about, or if you did not catch the question, and this might be something that happens right now due to maybe poor connection online, for example, and so there will be a break in between, or there's feedback, and so you couldn't really hear the question correctly. Ask the judge to either repeat or rephrase the question. Don't be afraid to do that, because it is always better to nail the answer to the question than to provide an answer that really doesn't meet the question. Yeah. So do that. And on the point of answering questions, it leads me to my fourth point, which is engaging the judges. Now, Prof. Jirai has also touched on this, making sure that the judges can follow your submissions. One of the ways that you can do that, one of the simple ways you can do that, is to actually guide them to the paragraphs of the mood problem or your submission which you are referring to. You don't have to do it for every single fact or every single point in your submission, but it's good to do it, especially at the start, so that they know, okay, that this person has a grasp on a good grasp on the facts, a good grasp on their own submission, and they're able to direct us to those relevant portions. Now, this is important because sometimes it depends on uh, how we process information, right? Some of us are really good at just auditory. So if somebody speaks to us, we're able to follow and we are engaged that way. Others require a mixture of reading and listening. And so if you are able to show them, okay, in our written submission, page 4, line 10, for example, we have laid out our contention on the issue of non-international armed conflict. I'm using an IHL term here, example here. Then it allows them to turn through those to that page, be able to see exactly what it is that you are speaking about. And so this is for guiding the judges when you are giving your submission. Also learn to read cues for when they might be thinking of asking questions, right? So if you see the judge looks like they're about to say something, what you might want to do is that provide an adequate pause in between your submission to ask so that they have the space to ask them questions. Because like I've mentioned, if you just steamroll ahead, so if your submission is very fast, or if your submission is just leaves no breathing room at all, judges might feel that they either do not have the room to ask you questions, or they feel that they do not want to interrupt your submission. And this is to your disadvantage. Now, this is especially important when we are doing this online, right? Because when we are doing it face to face, maybe it might be easier to judge cues. You can see their facial expressions. So right now what we can do is, of course, just look on Zoom or Microsoft Teams, whichever platform that you are running the competition on, and be sure to just scan the faces of the judges when you're doing this to make sure that they are engaged and that they are and just to make sure that you don't miss out on an opportunity to allow them to ask a question and to be able to show your preparation for the answers that you have to those questions. Yeah? And so on that point as well, I think Prof. Jiraya has mentioned reading. So one of the ways that we can sometimes miss cues is if we are reading. So right now, for example, if you're doing it online, it would be very easy to have like your script on half of the page and then Zoom being open on the other half of the page on the screen. And then when you're doing that, if you're looking at your script too much, you might not be able to catch what is happening there. So I would always tell my mooters to, ideally speaking, you should memorize your script. You should have it at the back of your hand. Obviously, this might not always be possible, but you really do not want to read because you miss out on a lot with that. Yeah? So the fifth point is utilizing of pauses and modulation of tone. Now, what do I mean by that? One of the easiest ways to add gravitas to your submission is to use pauses and tones to your advantage, right? Because pauses alerts the listener or the judges that you are about to say something crucial, and it builds a sense of expectancy. So if I say, I'm now moving on to my next point, and then I add maybe just a half beat there or one beat there, what that does is that, okay, I'm now primed, or the listener is now primed to, okay, they are now moving on to another important point, and they will pay attention. We can also speak louder to drive home a point. And so this is, for example, if you are making an especially strong point and you want to put an emphasis there, you can increase the tone of your voice. And you can also speak softer to drop your tone down in order to draw the listener in. Because once we drop maybe half a tone or one tone down, what it does then is that people then have to be, okay, what is it that they are saying? And they want to pay attention. Of course, don't drop yourself to the point where you are unintelligible, where people cannot follow at all what you are saying. And use this judiciously. Yeah? Don't do it throughout the entirety of your submission. This is going to be accent points. These are areas where you demonstrate a bit of style, a bit of flourish, a bit of control over your submission. So you might want to consider doing that. And my final point is, do not be slavishly bound to your script. This is something that we see very often, especially in new mooters. where you have a script and therefore you want to stick to your script almost exclusively, and this will almost certainly be to your detriment. Yeah, flexibility for mutas is key. You need to understand what you have covered, especially in the answers to your questions, and then not repeat them, right? So for example, I'm going to give an IHL example again. Usually how we would structure a IHL submission on a charge would be, you would talk about the elements of the charge first, and then you will talk about the liability next, right? So either it's individual criminal responsibility or command responsibility. Now, when you are talking about the elements, which is the first part of it, you might be asked questions on the criminal responsibility part, which is the second part of your submission. And what you do not want to do is to tell the judge, oh, Your Excellencies, I'm going to actually be dealing with that later on in my submission, so I will come to that soon. You don't want to do that. You want to answer the question, right? But when you are answering the question, you are moving to a part of the submission which is supposed to come maybe 3 or 4 minutes down the line. Once you have answered that, naturally you will go back again to where you had left off before the question had been asked to you. And when you do that, then when you come to the end of the elements, now in your script, what will come next would be your the part on the criminal liability, right? To show that you have that you are in control, to show that you are flexible, you might want to tell the judge that, Your Excellencies, I have already addressed the issue of the criminal liability, illustrated by the cases of whichever it is, and based on the principles of whichever that is, earlier, and therefore, and then you just want to summarize and conclude. You don't want to repeat your argument again. Now, this is something that comes through practice. The analogy that I would always give is that think about your favorite film, right? So maybe some of us, our favorite film is Avengers Endgame, let's say. And we know how Endgame is structured. It starts off with the death of Thanos, Thor kills Thanos. And I apologize if this is spoilers for anybody who hasn't watched Endgame yet, but it's already been 2 years. So, Thanos gets killed at the start, but then they realize that the Infinity Gems have all dissipated, right? And so there's a time travel element. They need to go back in time, find all the Infinity Gems, put them together, and then at the end of the film, there's the big showdown between Thanos and his armies and the Avengers, and all the ones that have been brought back to life again after the Infinity Gems have been put together. Now, if you are speaking about this film to your friends, for example, and then you say, oh, and the Infinity Gems at the start of the film have all disappeared, and then they ask you, but then how is it that, I think I saw trailers of the film and it seems like the gems were again in play, like what happened then? And so you can jump to the end of the film and say, oh yes, what happens is that actually at the end they had actually collected all the Infinity Gems already and they are battling out Thanos, and you can do that and jump back to where you left off, right? Because you know how the story flows, you know how everything links together, and you would ideally not repeat yourself again when you're talking about the story and arrive at the part where the end battle is, if you've already talked about that. And how this relates to mood is that you should be able to know your submission like your favorite film. You need to know how everything links together, what comes at the start, what comes in the middle, what comes at the end. You need to be able to jump back and forth, right? So practice that, learn how your arguments connect together, learn how it is that I can shift myself from the first part of my argument to maybe the last part of it and tie it back again to where I left off, and then, still be able to produce a cohesive overview of my arguments. You can only do that through, number one, practice, and number two, through a deep knowledge of how everything interlocks together. Yeah, that is very important. So these are just 6 tips. Yeah, I'll just go through them very quickly again. Take time to calm yourself, pace yourself, listen carefully to judges' questions, and don't be afraid to ask or seek clarification. Engage the judges, utilize pauses and modulation of tone, and finally, do not be slavishly bound to your script. And yeah, that's all I have for today, unless there are any questions, and I'd love to take questions from the floor. So, Madam Moderator, I think back over to you. Thank you.
Thank you, Mr. Joshua, for such a fantastic sharing session with us today. Ladies and gentlemen, now we will proceed to the Q&A session. Any audience may start asking questions to our distinguished speakers now. For those who wants to ask, please turn on your mic. If there's anyone who has problem with the mic, you may just put your question in the chat box. You may just put your question in the chat box. Anyone? There's a question in the chat box to both panelists. Are there any other ways to improve and develop fluency in conveying arguments other than self-practice or watching mooting videos, especially for those who have problems?
Stuttering.
Sorry, stuttering problems.
Prof. Chiraya, do you want to take this or?
Prof. Jurah, mic. You mute your mic.
Yes. Okay. I thought I want to ask Joshua to explain that better, because he can explain it better because he was a mooter and I'm not actually.
I can do it, Prof.
Leave it to you, Joshua.
I can do it. Yes.
Thank you.
I would say for if there are two things here. Number one is stuttering, and the second one is pronunciation. And so I'm going to address both of these. Now, stuttering can come up for a variety of reasons, and we want to be aware of why is it that we stutter. Is it brought about because of panic or because we're not calm, or is it just something that that is a condition that we have that we need to overcome? Now, if it's the first, then the way that you build calm is really, I think, to prepare as much as possible. And like I've mentioned, some of the things that we can do, take deep breaths before we start our submission. Tell yourself you are in control. I'm in control. I'm able to, I'm able to do this. Yeah. Pace yourself. So if you are if your words are very deliberate, if your pacing is very deliberate, that might minimize the stuttering. And so that is one thing. The second one, if it is a condition that we have, then we need to know what are the triggers, and also is there anything that we can do to overcome that. Now, some things that I've heard could help is breathing techniques. Learn to breathe. Do not be afraid to pause if we feel, oh, I am stuttering now and I cannot get the word out. It is perfectly fine to pause. Take a second to just collect yourself and then continue. And third, and I think this is really important, especially with pronunciation as well. It is very important that we go through our script many times. Like for myself, when I was a mooter, I will go through my script probably about 20 or 30 times a day. And when I say go through, I don't mean reading it. Yeah, I mean practicing it, saying it out loud. What happens when you do that is that you very quickly realize that there are actually some bits which look good on paper when you type it out, but then the flow of it might not be suitable for you. You might get stuck on either a turn of phrase or the way words are positioned with each other, or the pronunciation of certain words. What we want to do then is, if it is a word that is giving you trouble, right? If, for example, for whatever reason you cannot pronounce a certain word adequately, you want to look for synonyms. Look for something that you can replace it with. Yeah. So I'll give you an example. If you have difficulty pronouncing the word soldier, some of us do, then replace the word soldier with combatant. For example, if that is, there's a harder, there is a harder sound, the k in combatant, might make it easier for us to pronounce. And so you want to do that and refine your script and to the point where you are at ease with how you present it. Yeah? So just to recap, preparation, I think there's no substitute for that. Do that kind of preparation. Really temper, or not temper, but really work on your script to the point that you are very comfortable with it. And then if in the midst of the submission itself, you find yourself stuttering, when you find yourself losing a bit of control, it's okay to take a second. It's okay to breathe, take a breath, collect yourself, and then continue. Hopefully that will help you. Yeah. Prof. Jurai, anything else you want to add?
Yeah, I think there's the reason why you started. It's like what Joshua said is true. The important thing is have a clarity of mind and use simple language. That is the important thing to know, because you are trying to communicate. If you use language which is too big, yeah, and you yourself is not sure what is the meaning, then it will make you feel more startled, more nervous, and that's where then the flow of thought really lost you. All right. So again, understand and then use simple language to explain again. And yes, it's true. Take a pause. Take a few minute pause and then compose yourself. The pause must be together with take a deep breath, or at least a short breath, so that you are able to compose your mind and let the blood flow, so that you are able to gather and then plug in your mind the right word to use. Then it will be, because for sure we will not get someone who is stuttering too much to be a muter. Yeah, because there are times, because we do a selection when we know that you're good. The reason why you're stuttering because of something, because you're nervous, because something that not allow your mind to flow. So that is why, again, take a deep breath, compose your mind, yeah, and then use a simple explanation. So those are the things and how you can improve yourself.
I see there's another question here. Yes, on the how long do we take to look at the script or memorial to answer the judges? Now, I think Prof has mentioned this. Ideally speaking, you do not want to look at the script. That is ideally speaking. However, there are going to be times where your mind is just jammed and you feel that I can't, I really, like, I should know the answer to this and I have it in my script or I have it in my bundle, but I just can't reach it right now. In that kind of situation, it is perfectly all right to tell the judge that I need a moment to refer to my submission, if I may, and then take the time that you need. There is a difference. I think the question that is being asked here is that if you know that you have that answer somewhere in your bundle, I think it's a different question if you are totally unprepared for that question. So just to address the question at hand, yeah, I think it's as a judge, I don't mind if a muter needs to reach for their bundles or their submission just to have a quick look. I have only ever done it in my time as a student. I've only ever done it once. But if needs must, then go ahead and do it. You don't want to make that a habit. Yeah. Prof, over to you.
Yeah, I think I concur with Joshua on that matter. Yeah. Because we know it, because there's so many things that you're in your mind at that time, and suddenly when they just ask you those questions, now you know it's there, but you're not able to, and because your nervousness will make you overlook certain matters. So it's okay actually to ask time to look at your notes, and then, but make sure when you do that, your mind is working hard to think quickly, what answer, what is it that we don't want you to be like wasting the time but reading through and things like that. Yeah. So once you are able to find where the answer is, then you quickly look at the judge and give your answer.
There's another question in the chat box. Are there any tips that we can opt to in order to have a better persuasive skills?
Prof, please.
Again, persuasion means you want that person to listen to you, all right? I guess your body language is very important as well, all right? The way you express yourself, those are the natural thing, and those are the things that you can bring with you. In fact, that is with you when you present the court, yeah, to the court. So one is your body language, yeah, that is important, and the other one is basically the way you present yourself, clarity, fluent in language, all right? So one of the way to do it is speaking a simple language, but with a good tonation, with the right words, expressing things, yeah? So these are all the important weapons that is with you during the competition itself, all right? So you will be standing there, or you will be sitting down there looking at the judges. So what you have with you at that time is you yourself and your communication skill. So use that wisely, all right? And of course, the most important thing is if the judge asks you a question, understand that. Then by understanding, you'll be able to give a good answer, persuasive answer. If let's say the bench is very passive, that is not an easy thing actually for you to convince. But again, try as much as possible, because I'm sure when someone is talking nicely, someone is talking with full of meaning, it comes from the heart, it will reach the heart. All right. So that is how at that moment of time when you are presenting, use your body language, use your eye contact, use your voice, yeah, clarity of voice to explain to the court. I think that is the weapon is built in you. So use it to persuade. Yeah. That's all I can say.
Yes, I concur with Prof. And what I would say is that I think the most important skill for a mooter, especially when it comes to persuading the panel of judges, is being able to break down very complex arguments into easy to understand, in a manner that is easy to understand. Now, this might sound, you might tell me, yeah, this is easier said than done, right? But that's really what distinguishes between the best mooters and a good mooter, or an average mooter. You want to be able to, what I always drill into my mooters would be, when you are delivering your arguments, right, when you are speaking, it should be at a level where an ordinary law student or law practitioner who has no knowledge of the facts, no knowledge of anything about this particular area of law, will be able to listen to you and still be able to follow your arguments, right? So you really should train yourself on how to break down. There are some arguments that are going to have interlocking um, uh, areas or principles of law that you need to build upon each other. This principle first, then this principle next, this principle on top of that. And if you jumble them up, how are we as the judges going to be persuaded by your argument? You need to be able to be methodical in how you do that. I have seen that some of us maybe tend to think that persuasion is a matter of using flourishes, using extravagant language, or to show that you have a great command of the language. I would say maybe focus first on being able to deliver, or being able to bring your point across succinctly and clearly. And if you are able to do that and do that well, then we can talk about what kind of flourishes do we want to add. I'm just going to address very quickly the other question as well, which is how do we respond if we cannot answer the questions from the judge? Now, there's two ways this can come up. One of it is either that the question comes up and you know that you have the answer in your bundle, but you don't know how to answer on the spot. Then, as we have already discussed, ask for permission to just quickly have a look there and then answer the question. Secondly, there might be a situation where it's a question of a law or a statute or a case or a real life situation which you are unaware of. And what do you do in that situation? So I'll give you an example from the recent IHL, where in the mood itself, we were talking about the use of gold pills, and one of the questions that were asked to one of my mooters was that, with regard to that, the use of gold pills. So, do you agree with the Nazis' use of similar pills during World War II? Now, when that kind of question is posed to you, right, it is really well, it is a subjective question because it's a question of whether you agree or not. But it's also a question of objective fact. You need to know what is it that the Nazis did during World War II, and if you do not know, then how do we respond to that, right? If you genuinely have no knowledge at all about that particular subject matter, you need to inform the bench. You need to tell them, I do not know. Unfortunately, I am unaware of this particular use of pills by the Nazis in World War II. But then once you have said that, don't just leave it at that. Don't just stop there. Yeah? You want to pivot to something that can support your contention. I'll give you another example. When we talk about internationalized armed conflict, the landmark case is the Tadic case. Yeah? And if you are, during the course of submission, you refer to the case of Tadic, and the judge stops you and says, can you tell us what happened in the case of Tadic? And let's say you don't know what happened in the case of Tadic. You really, it's either stick your mind, it's not going to be in your bundles, you don't have it anywhere. What you want to do then is that you want to tell the judge, I am unaware of the facts here, and then you pivot to something that can support your particular contention. So, for example, another case would be the Lubanga case decided by the International Criminal Court, which deals with the similar principle as well. So we pivot and say, we don't know about Tadic, but I can tell you about Lubanga, and this is what happened in Lubanga. So whenever you answer a question to which you really do not know the answer to, apologize and say that you're not able to answer, and then pivot to something which is related to that. Yeah. So do not pivot into, I'm sorry, I can't answer your questions, and I'm just going to continue on with my submission. Say that you can't answer the question or answer that particular aspect of it, but I can show you something that is related. So that would show that you have done your preparation. It's just that you might have overlooked this one part. And I think the judges will be a bit more forgiving if you do something like that. Prof, please.
Oh, I don't know what else to say. It's all has been said by Joshua, actually. So I concur with him for that matter. Yeah, I guess it's honest answer is important as well because you do just save time. But of course, don't stop there. In other words, that that case maybe you do not know about it, but basically, at least clear out what is the position in this case. What is the facts that related facts in that case, so that you know that the thing in the position of your argument in here and the focus of it. Yeah, so that in other words that even though they ask you a question which is out of here, but to your mind, your stand is clear on that matter, and that is why you are hold on to that stand. That's it. Okay.
Thank you to our speakers for the inspiring speech. We as audience of the National Mood Workshop find this sharing very informative, which enable us to enhance our mooting skills. Ladies and gentlemen, lastly, as everything that begins has to end, sadly to say, our third session has finally come to an end. Therefore, I would like to convey my deepest apology and regret for any mistakes throughout my duty as the MC. On behalf of the Organizing Committee of National Mood Workshop, we would like to extend our warmest gratitude to our distinguished speakers, Professor Dr. Juria Binte Abdul Jalil and Mr. Joshua Teh Hongwan. Now let us have a visual photo session together. So I would like to invite all of you here to turn on your camera. Okay, 1, 2, 3. Okay. So we hope that you all have gained as much knowledge as possible. We will have a break for an hour. We will proceed to the fourth session at 2 p.m. Thank you for attending and have a good day ahead.
Thank you very much,
everyone.